Hello everyone, welcome to the CLE course on copywriting for attorneys, brought to you by PracticePanther. For the next 2 hours, we are going to delve into the wonderful, not always mystical world of English composition in terms of legal writing. So we're going to take you through step by step everything that you need to know how to be a better legal writer. I'm talking about everything from emails, affidavits, briefs, anything that you need as a lawyer to be a better writer. We're going to go through with them. It's going to be your much needed English refresher course if you haven't if you're not very familiar with that. First things first, I'm your professor for today, Eddie Bermudez. I'm the content marketer and chief imaginist here at PracticePanther. You can take a look at my contact information below. A little bit of my credentials. I have a little bit of experience teaching English and composition and general English rules to a wide audience. I've been a lecturer for many universities here in the South Florida area. So you can trust me to guide you through some of the worlds of some of the harder parts of English composition. But what are we going to talk about today? Very simple, very simple. I think in order to be a good, effective writer, a good, effective legal writer, there are some common rules and some common structure that we like to take over from the world of the humanities and composition and bring them over to the legal world. Maybe you're a lawyer, you were an English major at some point. Good for you. But we're going to take a look at some things like basic grammar rules, punctuation, commas, semicolons, all those tricky little punctuation rules that we tend to forget, that we think that we know, but maybe we tend to forget over time. I'm going to take you through common writing techniques and structures, how to pre-write, how to draft, the difference between passive and active voice, if you remember that from your second grade English class, summarizing versus analyzing. Sometimes your legal writing tends to fall into the category of summary, where you're just, repeating over and over again, step by step when something has happened. Sometimes that's effective, sometimes it isn't. We're going to learn how to sort of navigate that fine realm and know when to shift from summarizing to good analysis. Some of the legal documents we're going to cover, like I said, emails, motions, briefs, affidavits. We're going to go through some of the most basic pieces of legal writing you're going to be doing throughout your career, and much more. So we're going to, hopefully, for the next 2 hours, lots of time to cover, so we have a lot of things to go through, but I think ultimately a very informative class. A bit of a note that I want to say to you guys, do not just stop the CLE class before you get to about the halfway mark. I will be giving out 2 CLE credits for this course, but you will get the code for the CLE credits about halfway through the slides, so a little bit of a tricky game we're playing, so you actually stick through all the way through the presentation. But I don't know, I think I'm a bit of a charmer. I think if we can get through this. Why not? So let's begin. We have 2 hours. Let's go through it. The first half, I want to begin with just very, very basic. Let's not get too far into the weeds just yet. So just some basic introduction to what effective legal writing is, how to define legal writing, maybe a few characteristics, functions, features of legal writing. Some of this will be a little familiar, but I think it's worth repeating, worth going over just in case to refresh your minds, and maybe get a clear definition of what I mean by some of these things. So legal writing, good legal writing, the function of all good legal writing, I think does about three basic things. To establish rights and obligations, to distribute information, good complex legal information, and then last but not least, to enable communication within the legal profession. All right? So some of these should be a little obvious to you. A few features that all legal writing has in common, whether you're drafting an email to a client or you're writing an affidavit, whatsoever, and so on. A couple of features that all legal writing has in common, and some of these features tend to be a little more positive, some of them tend to be a little more negative. I wanted to show you these features just so we can take a look at what is going wrong and what might be going right with your own legal writing. So one common feature of all legal writing is extreme precision. You have to be very accurate in your legal writing, whether you're citing a specific case. In order to have that precision, you have to make sure that you know what you're talking about, so making sure they're using the proper legal language, the proper codes and what have you. But that type of precision tends to be a little obscure. Legal writing tends to be delve in the realm of ambiguity just a bit, because we use such complicated language, these archaisms in our structure and our vocabulary. Then the average layperson may not always be able to delve into a good piece of legal text like we smart lawyers can, and that tends to be a negative thing, a negative side of legal writing. We are so indebted to the formalism and the ritualism of legal writing. You know, we follow very specific structures, we follow very specific forms on how to write a specific document, how to cite a specific document. That tends to lead us down a path of maybe a bit of obscurity. Legal writing tends to be a little bit obscure. Part of it comes from our need for wordiness. We think that all legal writing should be intelligent writing, and then we open ourselves up to what I like to call fancy writing, which is these long, complex sentences, wordy sentences, when really we could be saying the same thing in about 5 words. I had an English professor who told me, like, why say something in 20 words when you can say it in 5? We tend to forget this rule. Short sentences doesn't mean that you are less intelligent. It doesn't mean that your writing is less intelligent. Lengthy, complicated sentences really don't lend themselves very well to understanding, and they don't exactly advertise your genius. Your words should speak for themselves, and if you can say the same thing in a very short amount of time, usually constructed with very simplistic terms, right? These terms of art that we like to use in legal language, for example, they tend to be a little too complex. We really don't need them. And we tend to also go for the passive voice, a passive construction. We'll talk more about active and passive voice in just a minute. That's one of the grammatical rules that people tend to have the most hang-ups in. Even law school students, that these are things that we should have learned in like the 2nd grade, but we tend to forget them just a little bit. But these are some common features of legal language. Some of them tend to be a little more positive, a little more negative than the other ones. A couple characteristics of legal English, of legal writing. We use some common words with specialized meanings. These words tend to be like very layperson words, but we tend to add a more complex meaning to them in order to stand in for something. Part of this comes from, we take a lot of Latinized words and Old English words into legal writing. Amicus curiae, for one, is being one example. That's a Latin word. I've done my homework. That's the one word that I'm sure about. Different origins for these words, and even though they tend to be incorporated into legal language, doesn't mean that someone without that training can easily grab onto them, right? Have a little training in Latin or so on. Specific terms of art that we like to use, and by terms of art, I'm meaning specific language, specific vocabulary that is only understandable, is only applicable in the legal realm. Different industries have different terms of art, so terms of art in the business world is different from the legal world. People tend to use a lot of those. Argot is very similar to that. These are specific terms or phrases that someone not in the legal field might not use in a conversation with a friend. Very, very formal words. Legal language is very formalized. Again, we wouldn't talk the same way we would to a friend as we would in a legal document. It requires a bit more formality. I'm not saying that's a bad thing. A good formality is always good in our documents to show your professionalism. But that formality taken to an extreme, where we're crafting these long, convoluted sentences that may somewhat make grammatical sense, but tend to get us lost in the weeds a bit. I want to get away from that just a bit. I want to show you guys how we can bring that formal style in a much more simple way. I know it seems a bit of an oxymoron, but I think we can get it. We can get through that. Some words tend to have more flexible meaning, but in that specific rule, we have that, again, extreme precision. You have to be very accurate when you're analyzing a specific law, a specific case, right? You want to make sure that you are talking about something that is relevant to that case, right? So you have to be very specific and very precise. And like I said, many words where one will do. That idea of wordiness, that idea of clutter in your vocabulary, in your language tends to bog down your writing. I want to make sure that your legal writing is not only precise, but you're not being bogged down too much. That way you can follow from one phrase to the next, one paragraph to the next, one sentence to the next. Okay? And again, I just want to go very briefly over some things. Again, we're not learning too much yet. I want to go slowly. Before I delve into the really complicated stuff. So just bear with me. There's just the first few slides. Just a couple things I want to keep in mind before we really delve into the complicated stuff. A few characteristics of good legal writing. So I've broken down what I think an A+ legal paper would look like, right? If you were taking a legal class, for example, what A+ legal writing should be about. And I think A+ legal writing should be about conciseness, completeness, courtesy, clarity, and correctness, right? The 5 C's. I like that. In order for you to be concise, you have to be accurate and analytical in your writing. Accurate in terms of citing the correct cases and then analyzing those cases correctly, right? We'll talk more in just a minute about summary versus analysis, but keep that in mind. Your citation has to be accurate and your writing should be also analytical. You just don't want to summarize somebody else's opinion over and over again. You have to really interpret and see what the law has to say, depending on the case you're talking about. Completeness. Completeness in terms of your sentences, in your organization of your structure, relevant and organized. The way you organize a paragraph, the way you organize an email, for example, you organize an affidavit, right? It can't be slapdash. Ideas originate from one central thesis, and then you elaborate upon those ideas in a specific organized pattern. We'll talk about more of that organizing pattern. We talk about pre-writing and drafting in just a moment, but keep that idea that legal writing isn't willy-nilly. There's a specific order and organization that goes through it in order for you to have a complete sentence, not just a complete sentence grammatically, but a complete idea that is carried out throughout that paragraph or carried out through that is carried out through that entire document. Courtesy, meaning thorough and specific and concrete sentences, thorough and specific citations you make in your references. You just can't, throw out a case from 50 years ago and not give a bit of context, a little background. Why are you citing this in the first place? Why is this specific or relevant to my discussion, right? It's just a common courtesy we give to the people who are going to be reading our legal writing. Clarity. Clarity in terms of the structure, that your sentences make grammatical sense, so you write complete sentence, but the logic is correct. An argument that has no logic to it, not going to stand up in court. So you have to make sure that you're citing the correct issue, that you're citing the correct cases, and that the logic for you citing that issue is correct, that it's clear, that you're not mumbling through your sentences, that it's logical, well-structured, well-organized, back to that organization, and that's correct for your reader. And finally, the idea of correctness being persuasive. You are a lawyer. Your whole job is to persuade, to convince, right? If you're doing a bad job of persuading a judge or whoever that your ruling is correct or that your client is doing something illegal, then you don't have a good writing. You don't have good writing. So I think by adding this semi-formula into our writing, by keeping these points in mind, I think we have a good general structure for what I think A+ writing should look like, right? What all A+ writing should consider and what all A+ writing, good legal writing, should sort of keep in mind. Very simple, very basic stuff. Which I think so far, I think most of you should be on top of the ball so far. I don't think I'm delving too complicated into a subject, but I think everything is good so far. These are some good characteristics for legal writing. What I have next is here, I think, guidelines for you. So here's something where we start getting to a bit more into the weeds here. Some guidelines that I have for you. So I think 8 simple rules for you to follow. 8 simple rules for you to keep in mind whether you're drafting an email to a client, whether you're drafting an affidavit or a brief or a motion, what have you. Some 8 simple rules for following to better improve your legal English. First things first, match function and style of the text according to the reader. This again goes into the pre-drafting phase, and we'll get into pre-drafting in just a moment. But before you begin actually sitting down on your computer, before you dedicate a bunch of hours to writing a specific legal text, make sure that you're matching the function and the style of that text to what's appropriate. If you're just drafting an email to your client, you may not want to use all those complicated, fancy legal terms. You may not want to detail every point that you're about to make in your legal argument. That might work better if you're drafting something for a judge, for example, or you're drafting something to an opposing counsel. What have you. So make sure that you're bringing the appropriate level of maturity, the appropriate level of style into whatever legal text you're writing. Again, a text for your client may not have the same complicated language that a text for a judge might have, right? Or a text for another lawyer. Keep that in mind. Avoid long and embedded sentences. Again, this issue, and I'm going to keep harking back on this because this is one of my pet peeves about writing. This idea that we have to have these long, drawn-out sentences in order to make our point. Not necessarily. As long as your punctuation is correct, as long as your style is correct, you're fine having short sentences. Short sentences are not a sign of weakness, or not a sign of you not getting the point. Actually, I think short sentences do a much better job. If you can encapsulate these complex ideas into shorter, more concise sentences, I see much greater maturity in that writing, and I appreciate that writing a lot more than I would authors who tend to, draw out paragraphs into 3, 4, 5 pages, right? We don't need that. It's really not necessary. By showing that conciseness in your writing, I think you can avoid a lot of people going back and having to reread your text, having to be lost sometimes. You don't want our reader to sort of like wander halfway through the text. What the hell just happened? Why? I don't understand how I got from point A to point B, right? And usually a lot of that happens when these long drawn out sentences that have no periods, that have no stops, right? At worst, they break grammatical rules. At best, they just tend to be very boring, very drawn out, very unnecessary. So keep that in mind. Avoid complex structure. Again, this idea about how you would transition between paragraphs, between ideas. Your structure does not have to be very complex. You don't have to go into the detailed minutia so quickly. There are ways of pacing our writing. We'll talk about pacing in just a moment. There are ways of pacing our writing so our structure is both great and fits into the style that we have to go with, but that's not too complicated. That's easy to follow for our readers. Whenever possible, try to use active voice instead of the passive voice. Passive voice tends to be a much more simpler style of writing, maybe a style of writing you're more familiar with. Legal writing especially tends to give a lot of wiggle room for passive voice, but it's not always the most grammatically correct form of writing we should use. So always, whenever possible, let's try to use active voice rather than passive. We'll talk more about that in just a moment. I'll show you some examples. Avoid double negatives, exceptions to exceptions, for example, right? Double negatives, we don't need them. They're just sloppy. They're bad. They're grammatically incorrect. Very similar to unnecessary synonyms. The most common example, null and void, for example. Null and void mean the exact same thing. You don't have to say null and void. Just say null or void. You don't need both of them. These double negatives and unnecessary synonyms. Apart from just adding again to that long embedded structure for sentences, just make your sentences sloppy. They make your sentences useless. You keep it simple, keep it precise, and I think stuff like that are just a little better for your writing to go really well. Technical terms and jargon. Again, legal jargon, while it may sound smart, while it may sound great, may not be appropriate for every piece of legal document. I would suggest cutting it back to only when absolutely necessary. If you're trying to elaborate a specific point and you need to bring in some legal jargon, bring it in. Make sure you're explaining it, but we don't need to have all your text, all your legal text and documents full of these jargons that you're citing from all these law books and all these case files. You don't always need them. Sometimes, just explaining them yourself and summarizing them just a bit will be enough for your reader to get it. And avoid Latin or any foreign words whenever possible. Again, I'll leave this up to your discretion. If you feel like a specific Latin term is appropriate and must be necessary in this text in order to clarify your point or to make a better argument, go for it. But if you don't really need it, if you can figure out another synonym for it or another word for it, by all means, try to avoid any of these overly complicated Latinized words. Again, part of my goal for today is to get you guys to realize that good legal writing does not have to necessarily exclude everybody who isn't a lawyer, anybody who isn't a judge, right? The common layperson should be able to navigate somewhat their way through legal writing. And I know, and I don't want to take any business away from you, but I'm sort of trying to democratize the tools of legal writing, just so not only so you become a better writer yourself, but so other people can pick up on your writing a little better. So just common little tips and tricks that I want to give you guys a general outline. Yeah. Ooh, perfect. The model for the writing process. So this is a model not just for legal writing. This is a model that I think is universal throughout all writing. Whether you're taking, a composition class, right, freshman year composition, or, you're taking an advanced creative writing class, what have you, all writing has a model that we follow. These 5 steps is the model we use for all writing, not just legal writing, but all writing. And all writing begins with the pre-writing stage. The pre-writing stage, this is before you get down in your word processor, start clickety-clacking away on your computer. You have to do a little pre-writing. This is where you clarify the objectives, right? You think about, okay, what needs to be accomplished in this text? What is the purpose of this text, and who am I writing this text for? Who are the readers, right? What is the scope of this document? You never want to go into your draft of a memo or an email, what have you, not knowing what you're going to write about. Let me save you a lot of time and heartache, and please, this is a lot of things that people forget. People think, oh, well, I have all these ideas, I should get them down on a piece of paper before I forget them. And while that is helpful to some people, I don't think that's the most efficient use of your time. You're drafting some documents that are maybe 25, 30 pages long. You don't want to spend 4 or 5 days on this, right? Let alone 4 or 5 hours. So I recommend pre-writing. Pre-writing helps you narrow down the focus and the scope and the objectives of your writing. It helps you define more clearly what needs to be clarified in your paper, what is relevant to discuss in your text, what sources, what citations you might need, and how long eventually you will take on this document, right? So I always recommend before you start doing any sort of serious writing, plan it out. Pre-writing is for that. It's your planning stage. It's before you go into battle. You're gonna plan out all your soldiers. You're gonna plan out all your moves, right? I just watched some Game of Thrones, so I'm all about strategy and warfare. So that those are the metaphors I'm gonna be using quite often. But that's what the pre-writing phase does, right? It really simplifies a lot of writing for you because it helps get a narrower focus of what you want to accomplish in this draft. So you're not wandering, you're not meandering. So your writing doesn't wander and meander later on. So once we have that pre-writing phase done, once you've established your scope, you know who you're writing towards and what you're writing for, the next phase is the information phase, right? This is where you'll be collecting all your resources, right? Now that you have a clear scope, right, you should have a definition of what needs to be accomplished, right? What cases might need to be cited? What information might need to be included? And this is where information gathering comes in, right? And this, you're sending out your spies, right? Your little birds. You're sending out your spies to gather all the information, right? If you're gonna bear with my Game of Thrones metaphor, this is where you're gonna be gathering all the information, picking out what documents are relevant, what documents are not, what fits into the general goal that you establish in the pre-writing phase. And again, this will save you a lot of time. Again, save yourself a lot of time and heartache. You don't want to be going through these long texts, hours of research. By doing the pre-writing, we establish what needs to be accomplished, and now in the information stage, we specifically tailor that information to the audience that we're going for. So if we're writing to a judge, if we're writing to a client, what have you, we have the information, we gather it up, and we have that information that's relevant, the specific information that's relevant to the purposes of our writing. Again, these are just time-saving tools. These are time-saving tools, how we save time in the writing process. And if you go through the steps, trust me, you'll cut back a lot of the time, you'll cut back a lot of the heartache, and really you'll just be a better writer. You'll cut back a lot of the mistakes that people who don't pre-write make. And that saves you a lot of editing time as well, right? I don't know how many of you hire editors, but they're a bit costly, and you can do editing yourself if you just go through these phases. So you have your structure, you have your information. Next step, organization, right? Here's where we do even more concise work. Here's where we start eliminating even more, and we just get down to the nitty-gritty, the bare bones of what needs to be accomplished in this writing, right? So we determine the organizational pattern, right? The paragraph topics, right? I would recommend you divide your paragraphs into topics, right? What I want to discuss in my first paragraph, what needs to be discussed in the second, how is that connected to my third paragraph, so on and so forth, right? The organization phase is where you start to plan out the actual skeleton of your writing, right? If the pre-writing was sort of like the prerequisite, sort of narrowing what was happening, here's where the actual skeleton, the body of your paper starts coming in, right? The actual substance, right? In this organization, we compare what the objectives are to the reader and the information you gathered. So you determine, okay, what cases are relevant here? Maybe you thought this specific legal document was relevant. Turns out it wasn't. All right, fine. We haven't even started writing yet, so that's fine. You haven't wasted so much time. Imagine if you found out that a specific case you're trying to cite and you're hinging your entire case on is no longer relevant, and you've written 10 pages. You've already written 10 pages on it. You've done nothing. You've wasted all this time, right? The organization phase is good because it helps you sort of set the skeleton of your paper. You know exactly where the ribs are going to go, where everything's going to go. So everything should follow a clear, organized pattern, right? You're transitioning from one idea to the next. Your ideas transition and flow very effectively, so you're not getting lost, right? So your reader's not getting lost, you're not getting lost, and your central ideas are always being carried out as effectively as you can, right? And that's in the organizing phase, right? So all these first three phases, I think, are nice phases that we like to do before we actually get down to the nitty-gritty. Now the second two is when we actually get down to the actual substance, the core of your writing, when you actually begin jotting things down. We have the drafting phase, the fourth phase, the drafting phase. This is where we put all the information into sentences, right? You're drafting, you're writing, right? You're putting your paragraphs together, you have your organizational pattern, so you should know where everything goes, right? If you did the pre-writing, the information organization phase, then this should not take you any time. The drafting phase should not take you hours and hours, depending on what legal document you're coming up with, but it shouldn't take you hours and hours because you already have the skeleton of your paper. You know exactly where the sentence should go, where this idea should go, what should come next. So you've drafted, you've pre-written, your drafting should go fine. Your drafting should go fine. Put your information down, your sentences, and we worry about things like grammar, revising, going back in the last phase, the revision phase, right? This is where we take a look at everything, right? We go sentence by sentence, paragraph by paragraph, right? Fixing the run-on sentences, improving grammar, correcting citations, spelling mistakes, right? Making sure everything is coherent, it's clear. If you're noticing an idea got lost here or there, that's where the revision phase comes in, right? Writing is all about revising. This is going to be the longest step of the process, right? Once you're done drafting everything, right, the only thing that's left is to improve it, right? To make sure we get us to that A. So the revision is what I recommend people take the longest time with. And always continuously revise. Don't just revise once, revise twice, 3 times, 4 times if necessary. Any good piece of writing that isn't drafted at least a minimum of 3 times isn't good writing. Isn't good writing at all. So each step of the revision, we go a little deeper, right? Maybe the first layer of revision is just about making sure that our ideas are clear, that our ideas are clearly stated. The second revision is about getting not just clarity, but also making sure our ideas are cohesive, right? That one paragraph is transitioning into the next very effectively. And then in the final revision, right, we focus on the more mundane stuff. Spelling mistakes, punctuation, grammar mistakes, run-on sentences, things like that, right? But revision will always be part of your writing. I would never, ever send out a first draft of anything. Even an email, even a plain email that's about a paragraph long that's sent to your client, I would always revise that at least twice. I never submit anything without clear revisions. And revisions could be yourself doing the revisions, or you can get someone else. Even better, get someone else to revise it for you. Having a fresh pair of eyes to revise your work for you can sometimes improve your writing and catch those mistakes that you might miss yourself, right? Getting a little distance from that writing. So I recommend you always get a second pair of eyes, a fresh pair of eyes to go by your revisions. And so that's the model of writing. That's the model of the writing process. That's how all writing takes place. And I wholeheartedly believe that if you follow these 5 steps, your writing is going to come out not just much better, but your writing will be much easier. It'll flow a lot more naturally, and you'll have so much extra time to just relax and revise. Relax, but revise as well. Relaxing while you're revising, right? Those are my 5 steps. All right. One important thing that I want to talk about is the idea of summary versus analysis. Now this is going to get a little technical, and it's going to go back to some of the basic principles that we covered, that you might have covered in like a basic composition class, you know, in high school or something. But it's worth defining the difference between summarizing and an analysis. A lot of your legal writing is going to require you to summarize certain cases, but a lot more of it is going to require you to actually interpret what is happening. And that's what analysis is. It's examination, it's evaluation, it's dissection, interpretation of an original opinion you might have, right? It's that reading between the lines, right? Connecting one idea to the next, connecting common pieces of knowledge, right? This is the goal of some legal writing, right? A good analyzer starts with a quotation, right? Or a question, and uses it to show his or her understanding and interpretation, right? That's what good legal writing does, right? I'm not saying all legal writing is going to require in-depth analysis, but a good majority of it is going to require good analytical skills. So I want you to keep that in mind. The difference between good examination, evaluation, dissection of the knowledge of the facts of a case versus just repetition, review, retelling, which is what summary is. It's a retelling of a scene or a story or a thought, or even the retelling of an interpretation of someone else. Summary is an original thought. Summary is just that. It's you retelling me, it's you re-encapsulating, recapturing, what have you, the idea of someone else, right? Summary shouldn't be the goal for most of your legal writing, right? It's usually a lot easier to summarize than it is to analyze, but it doesn't require much thought. It doesn't require much planning ahead of time. It also isn't very indicative of what I think good legal writing should be, which all legal writing should be analytical. It should be about explaining and interpreting your opinion, right? So it may be simpler, but not necessarily the most effective style of writing. So let's take a look at some examples. Here's some examples of what to avoid in terms of summary and what should be practiced in terms of analysis. So if you wouldn't mind just going back to your high school English class for just a moment, I'm sure most of you have read Great Gatsby. There's a great lawyer character in that novel, which I think works well for the theme of this course. But let's take a look at that passage in blue. Just a short little passage from The Great Gatsby, right? You know, Nick and Gatsby are driving together from West Side. They're having this conversation. Very nice. I love Great Gatsby, even if you haven't read it. But notice what's happening in that summary, right? If I was asking you what happened in that passage, what happened in what I summarized, well, I could just summarize it as the following, right? Nick is riding with Gatsby to lunch. He noticed that Gatsby is speaking differently, leaving his sentences unfinished. Gatsby asks Nick what he thinks of him. All right. Notice how there's no interpretation in this, right? It adds nothing to our understanding of the passage, right? If I ask you to explain this passage to me, all I've done was summarize it, right? I haven't interpreted anything. I haven't dissected what the meaning of this quote might mean, what Gatsby is trying to get across to Nick. It's simple summary, right? There's no interpretation here, right? You're just repeating, retelling, maybe rephrasing it just a bit, but same thing as summarizing. Rephrasing something is the same thing as summarizing something. Not really effective. So let's take a look at the next one. Analysis. Now, a little bit long. This is a bit long, but I think it's worth reading just so you can get a better idea of what I want to illustrate from this passage, right? So this passage sounds very different from the previous one, right? So if I can just read you the first portion there, right? In this scene, we see a break in Gatsby's affected calm, right? Nick had noticed previously that he had, quote, picked his words with care. I'm inserting a quotation in there, right? So in order to demonstrate the example, in order to demonstrate what analysis is about to come, I'm putting in a nice little piece of quote, right? A piece of text from The Great Gatsby. Now he leaves sentences unfinished. His agitation is seen also in his physical movements as he, quote, slaps himself indecisively on the knee, right? Setting the stage for myself. Gatsby's making plans to meet Daisy again, and his change in manner is brought on by his nervousness about seeing her. So now I'm giving you my interpretation. Why is Gatsby acting so nervous, so unusual, that nervousness of him meeting Daisy? Gatsby's insecurity about what Daisy might think of him after all these years leads him to ask Nick for his opinion of him, a fact which surprises Nick because it is such a change from the Gatsby's usual aloof confidence. This is excellent. This is analytical writing. Here's where you're giving me your interpretation. I'm laying out the facts for you, right? I'm laying out the scene for you. Nick and Gatsby in their car. Gatsby seems very different, very nervous. This is my interpretation of why his nervousness is sort of becoming so apparent here. He's insecure, right? This normally self-confident shtick that he puts on for people is suddenly broken down because of his love for Daisy, right? This is good analysis, right? This is what I mean about summary versus analysis, what good analytical writing looks like, right? We're using specific examples that tie back into the passage and moments of the books, right? That change our understanding, the meaning of what we read here. This is what good analytical writing should do, right? I'm not talking about just writing for like an English paper, right? You could use this if you're like in a college class or something. You could write this analytical form for an English paper, but I'm going to show you why this is important. Also, this type of analytical writing is important as well in legal writing itself. This type of analysis of maybe not, a classic work of literature, but analysis of a legal document or analysis of a court case, right? Or a past ruling. That is very important in all legal writing. An analysis of those past rulings or that past case to show your understanding and to lay out your arguments and your interpretation of that is also very important. So let's keep that analysis in mind. All right, so we finished that initial section, which I think it serves as the introductory portion of the CLE class. The next portion I want to get into are the actual nitty-gritty of things. Let's start actually delving into some nice rules and guidelines that you should follow in order to become a better legal writer, some basic principles for that. If the first section is how I'm dividing sort of the class, if the first section was a nice handy maybe guide, a few tips, some regulations for good legal writing, the next section I'm actually going to delve a little deeper into that, actually give you rules of form and structure that we should follow. That should be a little better for you guys. So now is when we really will start delving into some of the more important parts of it. So let's begin with what I think some really important things that we should cover, which is something that I think I've been saying a bit over and over again, but I'm going to keep repeating because I think it's so important. You know, repetition is a great way for you to remember this, to remember something. But one of the things that I really can't stress enough is, you know, keep it simple. Keep it plain. Keep your language plain and simple, right? Avoid whenever possible these overcomplicated terms and expressions in your writing. Eliminating foreign words like Latin words, archaic terms that might necessarily be useful to you, and eliminate any legal pairs and triplets, right? You know, following a sentence after with a complicated term, right, or a complicated reference to something. Again, you want to make sure that your argument is stated simply and clearly and concretely. We'll talk more about that in just a moment, but that's really important for you to remember, and something that I really want to get across to you. Is this idea of simplicity being very important, and just writing in plain English as much as possible. So a couple little ingredients for effective writing. These are the 5 parts, the 5 components of any good legal document. Number 1, having a main idea. Extremely important. If you don't know what the hell you're talking about, then you should be writing in the first place, right? Organization, having a clear structure. Supporting material, obviously the cases, the rulings that you're going to be citing, very important. You need to have some sort of backup and support. Expressions, your word choice and point of view. Again, things that we develop in the pre-drafting and the pre-writing phase of whenever you're crafting your legal document. You will plan out what references you want to include, what point of view you're coming from, sort of the general voice and tone and flow of the paper. And then last but not least, but certainly just as important as the previous 4, spelling, grammar, and punctuation. You should always consider, not just when you're revising and drafting, you know, am I spelling everything correctly, right? Is your grammar on point, your punctuation, everything of that? We'll go into grammar and punctuation in just a moment. I have an entire section dedicated to that, don't worry. But it's very important. That's why I think it's really important. But these are sort of 5 good principles that we're always going to follow. We should always keep in mind when trying to learn more about legal copywriting. So let's talk about paragraph organization just a moment. Again, these are things that we tend to forget, that we think we've mastered, but always worth going back and reviewing just a little for a moment. What I want to talk about here in terms of paragraph organization, you know, different cultures, different languages have different ways of organizing their paragraphs. You know, if you're a foreign lawyer, you may have been taught a different system, but I'm just going to assume, and for the purposes of this class, that we're going to be dealing with plain American English structure, right? And usually, paragraph structure is always formed on the basis of logic and organization, right? We introduce our logical statement and organize and develop that idea throughout in a very specific way. Every first sentence of a paragraph we call a topic sentence. And this is where you're going to tell the reader what this paragraph is about. What is the main idea? What is it that's going to be argued? What is it going to be structured through the rest of this paragraph, right? We always begin our paragraphs, right? A new paragraph that isn't connected to the previous one with a topic sentence, clearly laying out what is about to be discussed. Again, going back to the idea of organization and logic. What is the logic of this paragraph, right? The topic sentence will introduce that for me, and then you will lay it out and organize that idea as you go along through that paragraph. Any subsequent paragraphs, the sentences that follow, any subsequent sentences that follow will do 2 things. They will either support the topic sentence with some sort of reference or citation, or they will develop a topic sentence, right? Through that analysis, right? Forgetting, let's not forget our distinction we just covered between summarizing and analyzing. Again, making sure that your paper has substance. That's also part of that logic and organization structure. And anything after that, we call a sum up or a wrap up sentence. These are usually short sections after you maybe discuss something for at length that just puts a nice little cap on it, right? Any subsequent paragraphs or sentences that aren't, elaborating your point a bit more or aren't developing your idea a bit more, those are called wrap up or sum up sentences. And again, all they do is briefly, maybe in one sentence, summarize everything or the main idea that you've just discussed in the previous paragraph, right? And that's sort of the general organizing structure of all good legal documents, right? All legal documents should follow that structure. We're going to head a little deeper into that organization in just a moment, but this is sort of a general structure that you should follow, right? Again, keeping in mind, first sentence, your topic sentence, you will tell the reader what is happening in that paragraph. Any subsequent sentences following that should either immediately support or begin to discuss or develop the topic sentence or the idea you've introduced. And after that, you maybe want to have a little sum up or a little wrap up sentence that'll tie everything together, tie all the ideas together so it makes perfect sense for your reader. And that's good paragraph organization. That's how we structure everything so it makes sense, so it flows very accurately from one sentence to another, from one paragraph to another. 6 rules. I have 6 rules that I want you to follow. I'm actually being a little disingenuous because I have more than 6 rules coming up. But let's take it one step at a time. I first want to give you 6 rules for good legal writing. What are good rules that we should all follow when we're organizing our papers and when we're crafting our papers? And rule number 1, most important rule: have a point. You have to have a point, right? If you don't know what you're talking about, then you shouldn't be writing this paper, right? And I want to actually break down each one of these rules in just a moment, but let me just give you sort of all 6 rules now. You write them down and then fill in the blanks later. But have a point, most important rule. If you don't have a point, they need to get a point, right? Rule number 2, get a point if you don't have a point, right? You need to know what you're talking about. 3 is a rule about structure, right? We need to adopt a specific structure for your analysis, right? That'll allow you to integrate all the facts and citations and policies and past rulings into the actual body of your paper, right? So going back to that organization there's a structure now that we have to deal with. Rule number 4, we have to break up our analysis, right, into its component parts in order to so we can develop them separately. We do not want to write a legal document or a motion, what have you, that is maybe 2 paragraphs long, but each paragraph takes about 20 pages. One paragraph not be 20 pages, 10, 20 pages long, right? We have to break up our analysis. Break up our analysis so it's organized and makes logical sense, and you're breaking each component part up very effectively and in a way that makes logical sense, that flows very nicely. Rule number 5, tone. You have to adopt the measured tone. We'll talk more about, when we're being a little too colloquial versus when we have to be serious in our writing. Strike a nice balance in between. And then last but not least, be concrete and simplify whenever possible. Again, the idea of complicated sentences, just, letting, why write something in 20 words when you can write it in 5 words? Be concrete and simplify. So let's actually start heading into the actual nitty-gritty of each of these rules, and let's break them down. Rule number 1, have a point. Let's have a point. All good legal analysis, right? In order for you to do all good legal analysis, you have to have a point, what we call a thesis, right? Another word for having a point is to have your thesis, right? It's that central core, the core idea that you have for your paper, right? The core purpose, if you will. Lawyers tend to run into 2 problems when trying to have a point, right? They either don't have a point, then that comes from either being too descriptive about one topic, meaning that they're surveying the topic rather than analyzing it, right? Just going about summarizing key details and key points instead of actually taking the time to actually determine what those points mean. Why are those points relevant? Why are these points even being discussed, right? Or they maybe even show some ambivalence about the issue. If you are not sure about what the answer is, then you need to do more research. If you do not absolutely believe in the substance of your case or in the substance of your analysis, if you're ambivalent about trying to express that point, then don't write that legal document. Go back, do more research, do a bit more of your homework, and then once you have that confidence, once you're ready to argue that point, then you should be fine. You should be fine. But that's usually what tends to slip up lawyers when they're trying to conceive of a point, right? They're either they're settling for description, restating instead of actual deep analysis, or they're sort of ambivalent. They're not sure that they have the best argument, and so they're sort of going through the motions a bit. You never want to do that. Other problems that people might have is that they have too many points, right? You either have no points or you have too many points. It's easy to fall into that trap as well. You know, you're reading a lot, you have multiple cases, right? But very few people can actually write in depth about 3, 4, 5, 6 different things at one time. Keep it to one. Keep it to one thing. The aim of your thesis should be for you to explore one issue, one ruling, one piece of analysis, one purpose at a time, right? We shouldn't have to have one paragraph that has 5 different ideas colliding all at the same time. That just shows very messy writing. You're not going to develop every point that you can. I want you to focus on having one clear point that you want to develop across that paper. And if you're trying to develop 5 points at the same time, well, you're probably going to end up running into that ambivalence trap, where you're sort of not developing as clearly as you would one specific point when you're trying to develop 4 at the same time, right? So keep that idea in mind. Get a point, have a point, one singular point that's encapsulated in your thesis, and that will produce good analysis. That'll really make your paper really stand out. Rule number 2: get a point, right? Tell your reader what your point is, what it is you're gonna be writing about in the first paragraph, right? You have to get to your point as soon as possible, right? So once you have a point, tell it to me, right? Get it out there. I shouldn't have to wait until page 20 or 30 to see what the main idea was, right? I shouldn't have to figure out why I've spent, 2 hours reading this wonderful motion, right? And then find out that the purpose of it was on page 30. Page 1, I should know exactly what's happening, and because I have that idea guiding me, I know the exact purpose, or at least in theory, I should know the exact purpose, right? If you've organized and structured and pre-written your paper in the right way, then I should get the main point from the first paragraph, and then everything else should be a cakewalk for me, because I know the structure, I know exactly what the purpose is, what I should be looking out for, terms I should be looking out for, the reason why you're arguing this point, and then I can just go from there, right? If you take too long to bring your point, then readers tend to get lost. They tend to forget why they're even reading this in the first place. So another little clue for you, and a little tip for you, is to occasionally throughout your paper, especially if you're writing a longer draft of something, always have little reminders of what your thesis was, either through transitional phrases, right, or section titles to help sort of remind your reader just in case they get lost. You know, people have short attention spans. You may tell them your point in the first paragraph, but what if they're already on page 20? Maybe it's worth reminding them just very quickly, very briefly. You don't have to make a big point about it, but just get to your main point in the first paragraph, and then have little occasional hints just to refresh them a little bit as they go along. Yeah. Structure. So I'm going to give you an example of what I think is a bad structure, what I think is just not very effective structure for what your analysis should look like, in general, what your entire legal writing should look like. So this is what we consider. I have 7 steps here of what I consider, what a typical legal document will look like, right? What we think a good legal document will look like, but in reality, we're not really doing really good work. We begin with introduction, and again, in general, an introduction should be where you mention your thesis, right? This is where you get to the point, right? ASAP, you tell me what's happening. What I see in a lot of legal writing, and what I find I follow a lot of legal writing, is that people tend to forget that their introduction is there to introduce, right? That's the whole purpose, right? Is there to introduce the subject, the purpose of your writing. You never want the purpose, right? Your point to be lost somewhere on page 10, 15, 20 of your of whatever document you're crafting. Introduction, introduce your reader ASAP, get to the point, right? And that, again, will be a nice guide. After you have the introduction, then people tend to go for the background, right? Here's where you would lay out all the historical context of the problem, any past rulings, how different courts have handled the same issue, right? It essentially becomes an encyclopedia entry. And again, I don't want to say that you never need background. Of course, you always need things to help explain, background information to help explain any concepts to your reader. But when you have these long, drawn-out paragraph after paragraph of that summarizing, right? I can always go Wikipedia anything. With the internet, it's become easier than ever to find information on anything. So I could do some of that work for myself if I wanted to. But having an extended background section where you're really not saying much, where you're really still not saying, where you're just reiterating the points that other people have made, that tends to get a little tricky. I guess a little tricky. So you never want to have such an extended background section. After you introduce the background, then people tend to go for the facts, right? And the facts are just that, right? They tend to be these meandering recitations of things I've already heard about, or just the basic details of something. Very similar to the background, right? You're summarizing, right? You're going back and just reiterating, repeating, instead of actually making a good analytical point, right? Again, forgetting that purpose. Why? What are the implications of my interpretation of this law, right? The actual interpretation of the law matters much more than you just going ad nauseum about, and then on this year, this ruling did this, and this ruling did that, and the information from here, it tends to be a little too drawn out. Which brings us to the next part, the court decisions, right? You state the facts, and again, you're just reporting. You're just reporting issues or whatever pertinent to the case that may not develop the discussion in any effective way. And then finally, once we've all done that, right, and we may at this point be 10, 20 pages into a legal document, we have the analysis. You finally make a good point, about, the ruling, why you find the ruling of Court A faulty, and why you find Court B's ruling more in line with what you think the law should be. Good, finally. But I think at this point, once you reach page 20 or something, I think you've missed your opportunity. If your analysis really comes way too late, then you've kind of played your reader a bit, right? You've sort of strolled them along through this meandering plot, and then you haven't really adequately developed any details, right? You haven't established any relationship between one ruling and the next, so you must never forget that. You must never forget the basic principle of what good analysis should be. It shouldn't just be, again, more recitation. It should actually be an interpretation, breaking stuff down, right? Sort of dissecting a case, really dissecting a case, taking each of its component parts, right? Delving into them and seeing how they connect with one another. How you're actually formulating a good, effective counter-argument sometimes for someone else's ruling, right? And that's what good analysis should be. And then if you have that, and even if it does come too late, then usually people like to sort of have the policy implications of it, right? The next section they usually focus on is, if I'm sort of criticizing a ruling, right? Then what are the possible policy implications for that criticism, right? And mentioning some sort of policy implication, right? Could be part of your thesis. It could help be a part of that. But usually we tend to sort of trot out the policy implications way too late, near the end. At this point, I'm probably, if you follow this structure and I'm the reader, I'm probably really bored because I've read this entire history manual, and the really fun stuff didn't really start getting going until maybe the last 3 pages, right? You never want to reserve the most important part for just 3 simple pages at the end, right? And then last but not least, you have a conclusion, and this is rarely do we focus very much attention. I mean, come on, be honest with yourself. When was the last time you really took the time to craft like a well thought out descriptive conclusion? This is sometimes, again, very mechanical. You're just repeating everything you've just said. And if your legal document anyways has been, just background and court decisions and facts, and which are just repetitions of some of a legal document or a Wikipedia entry even, right? Then what have you written, right? What have you really substantially written? What if anything of substance is there, right? Is your analysis section as detailed as it should have been? This is bad writing. I think if you follow something like this, if you follow this formula, I think you should rethink it. So this, I think, was one of the most important sections. So I really want you to make a note of these so you can avoid these mistakes yourself. It's really important that you don't sort of draw out sections that don't need to be drawn, and you really focus on what needs to be done, which is good critical analysis and a good critical discussion of the case and what's important here. So just keep that in mind. I think this is a really important section. And we'll talk more in depth once I get to more of these rules later on. But this is a nice little overview for you. Speaking of analysis, fourth rule is we should break up analysis. Again, talking about the general structure and organization of your paragraphs. You never want your point to be missed out by your readers, so there are ways that we break up the analysis to make it more easy to digest for your reader. So one thing that I would recommend is you find ways to organize your analysis, right? There are many ways of doing this, but all these different ways of organizing and breaking down a structure have two things in common. One, your analysis must be broken down into its component parts, right? And each element must be examined and developed in an orderly and integrated way. So again, each portion, each thread. So once you begin dissecting a good legal case, right? Each portion that you're sort of dissecting and taking out is connected in some way. So you should be able to develop and examine each and every one of those parts, as long as they make sense and are relevant to your discussion, right? You never want to forget and leave an opening that someone else might say, well, you sort of missed this very important part of the legal ruling that sort of destroys your entire argument here, right? And the second thing I want you to focus on is that the structure of your paper should reflect those basic components, right? The arguments that you want to build and interpret throughout. And again, this is all done in the pre-writing phase, right? In the pre-writing phase, you are taking a look at what your analysis might be, what your central purpose might be, right? Doing that research to help you find out, okay, I want to discuss this, and I want to discuss point A and point B and point C. And then once you have what your discussion points are going to be, you're going to lay them out for yourself, right? You can even do a handy-dandy little guide for yourself. You can write it down, a very short little draft where you sort of guide yourself, and so you know exactly what it is you want to plan out, right? But they will follow a structure, right? There will be a set structure for you to follow. And again, if you've done the pre-writing portion, then that structure should be immediately clear to you. So you don't run the risk of sort of maybe delving into an area where you shouldn't, or forgetting a specific point and then having to go back and redraft and rewrite, even though you will be revising and drafting a lot. But your revising and drafting could take significantly shorter amount of time, if you already have that pre-writing done, if you already have a general structure for yourself, right? So these go into nice little tips that I have for you. Always make an outline before you begin writing. So what I just talked about, outline for yourself, sort of the general pace, the general flow of your essay, of your legal document, what have you. Try not to have more than 3 basic elements in your argument. That's usually the majority of people. That's as much as you can follow through. So 3 basic elements of your analysis should be about it. Maybe if you want to have a bit more, that's fine. Just be careful of that, and allow yourself time for revisions. Always be revising. Always be revising what you just wrote. It's an easy way of catching mistakes, and to maybe go back and see if I really did make that forceful analysis. Should I break things up even more? Should I go back and maybe elaborate on this point even more? Always leave room for that. Oh, tone. So this is a pretty simple rule. It's very important for all writing, not just legal writing, but it's important for all writing for you to be persuasive with your tone, right? To make your point effectively, but never be too aggressive or too nonchalant about your perspective or the argument that you're making. If you're too forceful with an argument, if you sound like you're being combative with your reader, they're going to be less receptive to your message overall. If you're too colloquial, they might think that you're not being serious, or maybe that you're uninformed about your topic, and you never want that to happen. So really, tone does affect the overall quality. So you should not only just watch out for the substance of your paper, right? Substance is very important, but the way that substance is delivered is actually very important as well. So always keep measured tone to your writing, impartial, just going through it very measured. You don't want to be boring, but sometimes, you can't get around that. I would rather sound measured than, sound so haphazard that people can't pay attention, or they can't pick up on my details. So always watch your tone. Make sure your tone is very respectful. Try to, even though we're trying to persuade others of our point, that persuasion will always come better in the form of a measured, reasoned discussion instead of someone yelling in your face, right? You don't want that. That's not the way of selling anything. So always watch your tone, watch your language, your word choice, and keep everything very measured. Don't settle for a conversational tone. Most people, some of the greatest writers in the world, right, strive for having a conversational tone in their writing, and end up failing horribly. If you don't have that training, I would suggest you not try to adopt such a colloquial tone. Again, there's not necessarily a conversation between two friends. Sometimes you'll be handing off your legal writing to a colleague or a judge even. So you want to make sure that everything's professional, everything's on point. Last but not least, be concrete and simplify whenever possible. Again, something that I have to repeat, something that I feel I have to go over and over with you is good writing should be about making the choice to be simple. Right, simplistic, excuse me. Keeping writing simplistic and concrete, right? Stay focused. Say what you need to say. Don't opt for these long, convoluted, abstract expressions. You don't need to be that way. By speaking abstractly, you are less likely to give actual concrete examples and illustrate your point, right? So settle for short sentences. Settle for getting to the point. Don't settle for fancy words, for fancy language. If you don't need to use such a verbose vocabulary, then don't be verbose, right? There's a cornucopia of words and phrases that we could use to sort of emphasize how intelligent we are, but really what's going to show off your intelligence, what's going to show off good writing is your analysis, right? It's going to be how effective you argue for your case and for your point. Fancy language just simply doesn't do that. It doesn't do anything to help strengthen or support your point at all. So just something that I like repeating, that I like, just trying to instill that into you, because I do think that's where we get a little tied up sometimes, right? And it's good to always, when you're revising, to go back and test yourself, to maybe have someone else read your paper for you to see, did you understand this? Is this sentence too abstract? Is this sentence a little too complex, right? Were you able to pick up on what it was going for? Engaging in subtlety is also not very good, right? You don't ever want to be subtle about your point. You never want to sort of be coy about the overall message or the point you're trying to make. Just be very straightforward with it. Be straightforward. Settle for very concrete. Get to the point. Just get to the point in your writing, and you should be fine. It shouldn't be a big deal. All right. So those are the 6 rules. Let's head into some other points that I want to get across, but I think 6 important rules for you to remember. Alright, so I said that there were 6 rules I wanted to teach you guys about legal writing, but I was being a little disingenuous. There are 11 more rules. So these are other great rules that you guys should know in order to be a good legal writer. And some of them will have a lot of crossover between the 6 that I just discussed, and and some of these will go a bit more in depth into these rules. But I think they're all important. So I think the 6 that I just gave you, plus the 11 that I'm going to go into detail now, are also very, very important for you guys to know. And again, these are just set guidelines that I think will definitely make you better legal writers, and I think these are rules that just should be followed in general. So these are 11 additional rules. We're gonna go through all of them. I suggest you write each of the individual ones down. Some of them, because they're so closely related to each other, I'll just be fusing them together, and I'll tell you when I'm fusing them together in terms of my PowerPoint. But these are sort of just 11 good rules, extra bonus additional rules that you guys should be following. So let's begin with the first one, which is just write your introduction, right? So we've talked about the introductory paragraph a bit more, but the introduction to all legal writing, I just want to make sure this point really hits home. It should serve as that roadmap. It should serve as a nice roadmap. It should introduce what's happening to your reader, to the major themes that will recur throughout the document, what you plan to be writing about, maybe give us a general outline for ourselves. But again, any brief, motion, etc. that you're going to be doing should have a good introduction. We must never forget introductory paragraph, and you'd be surprised by how easy it is to forget, how easy it is to sort of miss out on the opportunity to have a really good introduction. All good legal writing, right, for your readers, they should know the destination, which is the thesis of your paper, the intended route you tend to take, right, each individual elements and components you plan to pull your analysis from and develop throughout your paper, right? So this is really the chance for you to catch your reader's attention, right? It's a chance for you to really set the stage. First impressions are everything, right? So if you're not making a good first impression in your introduction, then you're not making a good impression on the reader overall. So just make sure, that's why I put it at number 1, always make sure that your introduction is very clear, that it's present, that it does what a good introduction should do. So just a nice roadmap, have your thesis in there, have the purpose, the goal of your paper right from the get-go, and you should be golden after that. You should be golden after that. Rule number 2, here's where we start getting a little more complicated. So make your case discussions as thorough and brief as possible. So going back to that bad structure I showed you, right? So when you're citing a case, when you're citing sort of a previous ruling, right? One golden rule to remember is that disembodied rules extracted from cases are worthless, are essentially worthless, right? To understand why the rule makes sense, right, you have to understand the particular circumstances in which the rule was applied, right? Any other considerations that went into that application, right? And this is where we start getting a bit closer into that analysis territory, where we start moving away from simply just summarizing what a ruling was to sort of the implications and the other applications and elements that went into that ruling, right? Again, really dissecting a piece of text, it will lead you to better analysis than just summarizing or reiterating something, right? So don't just mention a case text in your legal document, right, unless you want to provide a bit of context, right? Again, I'm not saying that we want to avoid summary altogether, but providing good context will be the time where you're going to be using summary. That context will just help, clarify any important or necessary details for your reader. But if your paper is entirely nothing but context, then that's really not setting the stage for any analysis, right? So set the stage with a bit of context, that's fine. But in general, try to immediately move into sort of developing what's important about this case, right? The individual circumstances that you're going to be discussing, right? And even if if you find that the context is not worth discussing, if the case can just be picked up easily, then avoid that summary and go directly into your actual discussion, right? That's what really is important. Have that thorough discussion in there, and anything else should be briefly just stated, and then move on to the meat of the actual substance of your actual paper, right? Rule number 3, another rule that I think may seem minor now, but I think ultimately does make sense. And it's I think it's very important to remember to have a strong opening line for each of your case discussions, right? Don't just settle for the very rot way of beginning a sentence or a paragraph, which we all like to do, is like in case A versus case B, right? So in A versus B, or in C versus D, right? That's usually what we like to do, right? We cite the specific legal challenge, right? And that tends to be very repetitive, right? If you're reading 20 pages of every sentence beginning with in A versus B or in C versus D, what have you, it gets boring. You need a little bit of variety, right? Do a little more research into your transitional phrases, right? We'll mention transitions in just a moment later on, but don't let your paragraphs be boring, right? These are people, your legal the people who are going to be reading your motions, your briefs, right? They probably have a lot of other things on their plate. So whatever you can do to make it as engaging, to have that lead-in sentence be as engaging as possible, will ultimately help out your writing. And again, some of these are aesthetics. These are issues of writing aesthetics, which I think are just as important as the actual substance and analysis that you bring to your writing. Sometimes you have to be catchy. You have to make something important. You have to make something catchy and make something entertaining for your reader in order to get them to move on and continue along. And then you're allowed to be a little boring after that. Once you have them hooked, you're allowed to be a little boring, but always have sort of these moments where you're bringing them back in, right? Rule 4 and 5, the extra rule 4 and 5 sort of applies to transitions and resolving issues within your own paper. So I just mentioned that your lead-in sentences should be try to at least try to be a little more varied. Don't just settle for the same formula over again. Often we like to write in chunks. Your paragraphs are divided into chunks, right? So a good draft should try to, especially in the pre-writing side, should try to form a pattern, right? So try to make that paragraph flow. Make one chunk flow into the next and transition to the next, right? This is where your transitional phrases, your transitional words start getting into play. Again, up to this point, you should be somewhat familiar with what a transitional phrase is. I recommend you do some additional research on this. They're very, very easy. These are the phrases like moreover, furthermore, also, so, and, right, in conclusion, first, second, third. There are a few transitional phrases, but there aren't that many where I don't encourage you to just do a quick little Google search and just look them up, become familiar what the appropriate transitional word or phrase might be for a specific situation. But your paragraph should flow very nicely. They shouldn't start and stop, right? That's another aesthetic quality about your paper, right? If your reader, while they're going through your memo or what have you, is sort of having to start and stop and trying to find their place, it really doesn't bode well for your writing, the professionalism of your writing. So finding that right transition, so everything sort of flows very neatly, everything goes from one section to the next. That'll make your paper and your writing sound so much better. Another rule that people sort of struggle with is this idea of resolving issues. This is also a transition problem, and that occurs in that back and forth that we experience between citing the pros and cons of each issue, right? Having the pros and cons of each and every argument that you're trying to go for. You need a sense of closure, right? A sense of closure for one issue before you go on to the next, right? So if you're sort of debating with yourself, the pros and cons of one issue in one paragraph, it's creating conflict in that paper. So have a sense of closure. Finish off the pros. Then in the next paragraph, transition, have a transitional phrase, and then go to the cons, right? And then take it from there, right? That shows much better organization. It shows much better paragraph structure, right? And the logic is much more clear in that way, right? Less of that starting and stopping, less of that debate, right? Again, you don't want to confuse your reader, so always resolve those issues immediately, right? Take it one step at a time, right? Going back again to those important rules about breaking up your analysis so it makes sense. This is what I want. This is what I mean by that. Sort of having a nice way to improve that flow, and that you're resolving any conflicts, right? So I'm not left wondering, well, so what is the point here? What is the point of this paragraph, right? Having those sections and transitioning into each one of those sections is very important for your writing as well. So just a little something to keep in mind. Rule number 6 about footnotes. So you should be familiar with footnotes at this point. Footnotes have a lot of different purposes for them, right? So I suggest you have good footnotes. I suggest you keep footnotes in mind, not just when you're specifically citing or referencing a case or some other outside source into your paper. Footnotes are always important for that, but they could also be used to illustrate a different point or a generalization that you have made about a text, right? To give further details about some sort of material or subject or topic you've just introduced, right? Maybe this is where you maybe explain a legal term or explain a complicated definition you just given. So always keep out for the various reasons why you want to have footnotes. I have no issues against having footnotes. If you want to have a bunch of footnotes, that's fine, as long as your footnotes are accurately cited and they're placed in the right areas. It's fine to have footnotes. They tend to solve that bit of that summary problem, since you can go into a bit more of a context or go into further details that might be inappropriate in the body of your paper, but might fit better in a footnote. So I would just consider keeping footnotes in mind. Don't forget about footnotes. Don't think that footnotes are just there for when you're making a specific citation, right? There are various purposes for footnotes. I've put in there 6 of the most common ones, so just always keep that in mind, that footnotes have more uses than just to cite something. They could help you out in other ways as well. So footnotes very important as well. The extra tips for number 7, number 8 all involve quotations. When we talk about quotations, specifically when we insert those direct word-for-word quotations into your paper, there's nothing more lazy than ending a sentence with a quotation. Typically the rule of thumb is we never begin a sentence with a quotation. We don't ever want to end a sentence with a quotation. So I want us to really stress how sort of lazy that looks for your writing. To really tie in your that quotation with your argument and emphasize the point you're trying to make with that quotation is key for all good analytical writing. You never want to end a sentence with a random quote and then not have your reader know what the hell is happening, right? Or why that quote was even inserted there in the first place. Long quotations also don't help your paper. A good rule of thumb, typically for more than 10 continuous lines of indented single-space quotation in your text at any one time. That's usually about the good rule of thumb to keep. Try to break up your quotes with ellipses if you can, right? Eliminating anything that isn't necessary for you. It's a good rule. So always make sure that not to skimp on quotations, but when you do plan to use them correctly and use them accurately. When you're transitioning into a quotation, also very important for you to learn never to finish a sentence with a quotation. Again, rules of aesthetics, but they ultimately help out your paper a bit more. And also, again, avoiding those long, drawn-out quotations. I hate reading like a paper or something that I think is writing, and then I start noticing, oh no, it's one long quote. This entire paragraph is one long quote. They haven't indented anything. They just put quotation marks around it. I miss the quotation marks, and I think, oh, look how informative this writing is, and oh, well, someone else wrote it. So it turns out it was just a quote, and now they're beginning their next part of the discussion. Don't avoid that. Try to avoid that. I don't like to be tricked like that. So be very precise with how you're going to be using your quotations, and be very succinct and concise about your quotations as well. Rules number 9 and number 10, just moving right through this. Rules number 9 and number 10 involve simplicity and form. And again, you're probably already tired of hearing, simplify your writing. Don't go for the fancy legal flourishes and literary flourishes that we like to bring into our writing that make you sound smarter. I love this rule of simplicity. It's why I keep repeating it. It's why it's in almost all of my sections. But I promise I won't harp on it for too long. Probably we're too late for that. But it's worth stating. It's worth stating. Keep it simple, to the point, and keep it clear, right? And why I stress simplicity is that it's, again, this issue of clarity, of making sure that your point is getting across. Again, usually you're not going to be there when you're trying to explain a point to somebody. So if it's not immediately relevant or clear what your point is to your reader, then you've missed a golden opportunity to try to persuade them. You're not going to be sitting there, by their side where they can ask you a question about, what did you mean by this, right? So you have to make sure that your writing is as clear as possible, that your point is getting across as possible, and that simplicity and that clarity will help the overall persuasiveness of your memo, your brief, what have you. So I'll just keep stating these rules, and I'll keep adding them into there just for your own benefit. A few rules in particular you should remember about the form and structure of your paper. Always cite cases and statutes in proper Blue Book form. Your lawyers should all be familiar with the Blue Book structure. If you don't have it, or if you forgot it in someone else's dorm or right somewhere, go buy it again. You know, I highly suggest you have it with you. Keep up to date if any updates are happening. But Blue Book is important. That structure in order for your citations is very important. If you're going to structure something, you must make sure that your citations are part of that structure. So always have that proper citation in hand. Never split infinitives. These are grammar rules. Just look those up. You know, split infinitives are one of those rules. You know, your word processor will catch them for you, but you know, these are grammar rules you should focus on. Spell all your words correctly. Obviously, of course. This will come up in the revision phase. You know, if you're always catching these, you know, your word has something to help catch you. I would suggest you install a free program called Grammarly onto your Word document if that's what you use. If you're a PC user, you know, it'll help catch some of these texts for yourself and show you neat ways of fixing them, and it'll also explain the grammatical rules of why it went wrong. So you're learning, not just, you know, having a program fix everything for you. Don't get cute about personal pronouns. Things like he slash she, or he or she are just fine. But having singular pronouns like just she for everything you cite or just he for everything you cite is a bit too inappropriate. You know, have both pronouns he slash she, him or her, in there. Don't just settle for one pronoun. You know, it's a little offensive if you just have he said, he. Like, you know, you know, women have contributed to legal rulings and legal documents before, so, you know, just don't attribute a male pronoun to a female author. Always cover your bases, and just for clarity's sake, have he slash she, and that should avoid any of those rules. Watch out for run-on sentences, grammar mistakes, diction, anything else like that. We'll get into run-on sentences, we'll get into grammar mistakes and punctuation in just a minute in the next section, but always worth having a little bit more background information about what a split infinitive is or what a run-on sentence is. Do that little bit of extra homework for yourself. These rules are not that hard to understand. There are plenty of resources out there on the internet for you to use if you just want to maybe quickly look up, you know, what a run-on sentence looks like. But you know, you're a very smart individual. I am sure you don't make mistakes that often, but we tend to forget. We tend to forget sometimes, and it's, you know, we make mistakes always. So you never want your paper to be hindered by just general sloppiness because you didn't take the time to, you know, really watch the grammar here, really watch your tone here, the diction. So just some common rules for you to remember, part of that simplicity in form. And the last one up, consider the policy implications of your thesis. One thing that we might tend to forget or skip over is that no writing that you do, no legal writing, almost none of the legal writing you do is in a vacuum. They will have real world effects. So always keep that in mind. Words have power. They can serve the basis of action, right? How things will be carried out, and you as a legal professional have that amazing ability to truly say that your words do matter. Your words will have a direct impact on someone's lives, maybe the lives of this entire country. You never know. So keep that in mind. I have some questions for you to think about as you're constructing your legal document. Maybe take a look at these in the pre-writing phase. Begin to think about these in the pre-writing phase of your writing. You know, what effect will the rule you propose have on the way that the world works, for example? Is the effect you seek to bring at a cost of something, or is it worth the cost? Just, you know, rules that I would consider. Just thinking about as you're crafting your document. So just think about that. Just a nice rule to really think about when you're determining, you know, when your words do have that much power, and your words do have power as an attorney. It may be just in the lives of an individual, an entire company, or a group, or an entire nation, but your words have power. So it's very important to just consider that. What policy might be in place after that? It's always important for you to consider. Alright, so let's move on to the next section, the next portion of this, which involves all the wonderful punctuations and other basic grammatical rules that I think are very important. I'm going to mostly breeze by. I'm going to very quickly this section, just because I'm going to be talking about a lot of very basic grammar rules in terms of like commas and quotations, apostrophes, things like that. We'll talk about active voice versus passive voice, hyphenations. But it's going to be a relatively shorter section. It's just I want to detail a few, I think, of the most important and easy to miss grammar mistakes that we make in our writing. We tend to think that we're the masters of proper semicolon use. If you use semicolons at all, I personally don't use them, but even if you do think you're a master semicolon user, you may be missing some rules. So I think it's worthy of a quick glance through some basic punctuation rules. Lynn Truss wrote a great book, which I think it encapsulates why I find punctuation rules so important, why we should follow punctuation rules. You know, these wonderful little memes I have there on the PowerPoint sort of demonstrate why I think following really strict punctuation is better. And again, this goes back into this idea of the professionalism that you present in your legal writing. You don't want, you have some nitpickers out there who will go after you with with a misplaced comma here or a dangling participle there. So I want to make sure that you don't put yourself in that situation. So let's just go through some of these very quickly. Important grammar rules for you to remember. But I want to begin with a bit of a pop quiz. Yes, you will have a quiz. I promise you won't have too many. But let's take a look at this. I have a sentence there for you. Feel free to pause the webinar now if you just want to take a moment, follow along. But here is a sentence, and I want you to tell me how many mistakes you find in the sentence. How many mistakes you see in the sentence. Very simple, A, B, C, or D. So go ahead and pause the webinar now. Wait a second or two. Think of the answer. And so I think the answer for this is D. There are 4 grammatical mistakes here, all involving punctuation. Specifically, there should be a comma after Mr. Silverstone, a comma after the company, a colon after including, once you're listing out those company names, a comma after construction, even though that final comma, where it says Spacely Construction, that final comma is the optional Oxford comma. The Oxford comma, very controversial. Maybe sometimes you follow you put a comma before the and at the end of that list. Sometimes you don't. There's a debate on that, but I included it there just in case you recognize it. And again, a lot of these grammar rules are very simple. You can go look them up yourselves, and just if you really want to get more into detail. But as we're going through this specific section of the webinar, just for your own benefit, for yourself, create a checklist for yourself. Have a little checklist. We'll be going over commas, colons, semicolons, apostrophes, hyphens, quotations, exclamation points, all those wonderful things and more as we move through this specific portion of the webinar. So just go through a list. Go through what your own weaknesses are. If you're really strong with commas, then don't worry about them. But if you're sort of weak with semicolons, then spend a little time with them. But just go through a list of yourself. Create a list as we're going through the rules, just so you're clear about what the rules mean and how to follow those rules. But let's begin with the most basic of all, commas and conjunctions. When separating 2 independent clauses, they are joined with that are joined with a conjunction and, but, for, or nor. We always place a comma before that conjunction. So for in the examples, defense was inadequate. That comma should go first, then followed by the but. That's the conjunction. And effective appeal is still possible. The results are misleading, comma, and they must be ignored. Right? So this is where we always add a comma after a conjunction. But we never place a comma between a compound verb. Remember, this usually happens when we have an independent clause and a dependent clause, excuse me. So if you take a look at that sentence, the lawyer filed the brief and served opposing counsel. We notice that and is joining that independent clause, the lawyer filed the brief. that's a complete sentence. The lawyer filed a brief is a complete sentence. However, served opposing counsel is not a complete sentence. So in order to make that a complete sentence, we had to use that compound and to fuse them together. So we never use a comma between that and. It just doesn't make sense. The firm received the invoice, complete sentence. Processed it for payment, not a complete sentence. That's missing something. The and fuses them together, so we do not place a comma after that between a compound verb. So just remember that rule for you. Comes with an introductory element. Usually introductory element sets off, usually a transitional phrase or something. A part of the sets off the rest of the sentence from that introductory element. For example, while we were eating, comma, a skunk appeared. Laughing out loud, she disrupted the class. Although she has retired, she's still active. These are all proper ways of putting a comma after that introductory element. A little tip there on the side, if you delete the introductory element and if what remains is a complete sentence, then you know the deleted material is an introductory element. So a skunk appeared is still a complete sentence, right? You don't need while we were eating to make it a complete independent clause. So we know that while we were eating is an introductory element. So we place a comma after that introductory element. So just a quick little rule. If you find that the introductory element is absolutely necessary for you to have that complete sentence, then we go back to the previous comma rule. They are optional because English languages always has these weird rules. A comma is sometimes optional for short prepositional phrases of fewer than 3 or 4 words, if it's not confusing to the reader. For example, around midnight the pumpkin carriage arrived. We wouldn't need to put a comma there. After a single adverb, for example, soon it will start to snow. We don't need to put a comma there. So that's optional. So we do have these occasional exceptions to the rule that just, they tend to maybe complicate things just a little bit, but they're easy to keep up with, and you normally won't find too many examples. Commas and non-essential clauses, they set apart non-essential adjective clauses, or what we call interrupters. Congress, not the court, should change the law. We place not the court in between those commas, since these non-essential clauses, right, they provide additional meaning about the modified noun, in this case the modified noun being Congress, but as long as it doesn't change the meaning, right, we set them off with the comma. So as long as those interrupters are just modifying the noun, they're not changing its original meaning, then we place those that interrupter in between those commas. But the exception is if they set off, right, a necessary or defining clause, then we do not put the comma in there. So all legislators who are members of the Democratic Party will likely sign the bill. You might be thinking, okay, so all legislators, comma, who are members of the Democratic Party, comma, will likely sign the bill. However, that's not the same thing. Note my rule. If that adjective clause changes the meaning of the noun, they modify by limiting it or restricting it in a significant way, then they are not set off with commas, right? In this case, right, legislators would be your noun, and the who are members of the Democratic Party are helping that, our understanding of that and changing the meaning of that around, so we do not put that in between commas. We have to make sure that's very important. So again, a little tricky, but I think simple enough for you to understand. So just watch out for that. What is being modified and the intention of that modifying. Oops, a little quickly there. So here's another quiz, just to maybe have a greater elaboration on that point. So take a look at the sentence. Is this sentence punctuated correctly? And again, you can pause it yourself, take a minute, go back to the rule, and see if the sentence is punctuated correctly. So let's take a look at that sentence. And the answer is no. No, it is not. You should take a look at where these commas are actually being placed. Know the differences here, right? Between these are two correctly punctuated sentences. They're saying the same thing, but make sure what is being placed here to see how it's different from the first one. So the lawnmower that is broken is in the garage, but John is now using the other one to cut the grass. You're identifying what the lawnmowers as two separate things, right? And the second one, the lawnmower which is broken, is in the garage. It adds a fact here. Here we have that modifier that stating a fact about the lawnmower. So we would place that in that interrupter in between those two commas here. So that's how we would fix that punctuation mistake. And again, you can go back and look at these again. But very simple quiz. Commas for items in a series, again, very simple. Always separate items in a series with a comma. You could choose the Oxford comma. Again, that's optional. You can look more up. The burglar stole the victim's credit cards, commas, checks, commas, and cash. Some people would not put, if you're going to be following the Oxford comma rule, some people would not put the comma after checks. They would just say cards, comma, checks, and cash, either one. But we would never put it after the last item in a series. The flyer promised a fuel-efficient, fast, elegant convertible. You see that the last item in the series does not follow the Oxford comma rule. It does not follow the comma rule. So just keep that in mind. Commas with positives. Positives, another one of these wonderful, not very complex, but just a bit annoying grammar rules that we should follow. With a non-essential positive, which is a pronoun, which is a noun or pronoun that renames the noun it follows, then we put a comma. The representatives from Massachusetts, comma, a Democrat, comma, voted for the bill. This is a non-essential positive. Versus Joyce's book, Ulysses, contains many poignant insights. That's an essential positive, right? Like adjective clauses of positives can be essential or non-essential. Essential positives are set off with commas, while non-essential ones are not, right? So just figure out which is an essential positive and which is not. So look out for the noun and pronoun use in those. Commas with names, dates, and addresses. Again, another very simple comma rule we tend to maybe forget. Always punctuate geographical names, dates, and addresses, but not before a zip code. So, for example, Plainton lives at 400 Commonwealth Avenue, comma, Boston, comma, Massachusetts, 02117. Now we have a perfectly punctuated address line right there. You can also have a comma after the year and a date. For example, she left her vacation on Italy on September 4th, comma, 1998, comma, and has still not returned. Bit of a dark example, but I think worth noting of where we put those commas after the date. Commas with titles. Comma with titles also very important. Again, one of these rules that we tend to forget. We're probably not even thinking about it very much because, you know, unless we're writing English papers every day, we don't think about these rules. But always, where titles follow a name, we always place a comma. Andrea Banks, put a comma between her title. Practices with Center Pediatrics, for example. Filippo Grande, comma, UN Commissioner for Refugees, comma, spoke to the Assembly. Perfect use of correct grammatical use of commas there. The comma splice. So I want to spend a moment here because the comma splice is actually one of the most commonly used errors in writing, and so I want you to pay special attention to when that comma splice is happening, especially since we have all these rules about, you know, coordinating conjunctions and regular conjunctions and appositives, so it's easy to fall into the comma splice trap. So watch out for commas placed where periods or semicolons belong. Remember, commas are not a full stop. They're very only for the specific purpose of showing a pause in a sentence. So for example, we ate a huge meal, we slept afterwards. This is a comma splice. We're using a comma here incorrectly in place of putting a period. As you can tell, we ate a huge meal and we slept afterwards are two independent clauses. They can belong separately. They stand on their own. We don't need that comma to join them. Typically, we would place and there. That would be a much better use of a grammatical tool. We ate a huge meal and we slept afterwards would be the grammatically correct phrasing. Or we can just, instead of placing that comma there, we can have a period. So never place commas where a period or some sort of conjunction would make a better would be a better choice there for you. Another example, she found the course challenging, however, she received a high grade. In this case, we would have to place, instead of that comma, between challenging and however, should be a semicolon. We'll talk more about proper semicolon use in just a minute, but in this case, a semicolon would be appropriate before the however, and then the comma would go after the however. Speaking of semicolons, semicolons tend to be one of the more complicated grammatical tools that we use. Like I said a little bit earlier, I don't necessarily use them. I try to avoid them a bit. I'm very much in the Ernest Hemingway school of writing. You know, periods and commas with the occasional exclamation point every once in a while. But you know, they're not a complicated grammatical tool to learn. So just a little rule of thumb for you: semicolons separate major sentence elements of equal grammatical rank. Generally, we use them when you have a complete clause either on either side of the semicolon and cannot bear to split the clauses into separate sentences. I think that's easy to remember. Depends on what sentence you're talking about. The example I have here: an important witness was out of the country, however the trial took place without her. As you can see, both these sentences can stand by themselves, but we can't afford to split them since they're sort of really tied with each other. So the however makes sense there as long as you have the semicolon first. So just a simple semicolon rule for you guys to follow. Semicolons, make sure that you use a semicolon between independent clauses linked with a transitional expression. However, therefore, similarly, moreover, these are all transitional expressions that we can use. Typically, we can attach a semicolon before them. The artwork was extremely rare, comma would be incorrect in this case. It would be the artwork is extremely rare, semicolon. However, it sold for only a few $100s. So just basic semicolon rules for that. As an item separator, we tend to use semicolons when we're using specific items in a list. For example, if we're listing no talking, no eating, no running, the way we would do that is to have the semicolon within that list, right? No talking, semicolon, no eating, especially since we're listing that in numbers, right? We wouldn't just have a semicolon stand in for the colon in this case, right? The library has 3 important rules. We do not have to have a semicolon there. A colon would be the appropriate grammatical mark to put there, and then divide the number, the listed items with a semicolon. No talking, semicolon, no eating, semicolon, and no running. Semicolons are not colons like we just had in the example before. So again, be careful what you're using a semicolon for, so don't replace other appropriate grammatical devices with a semicolon. The example I have here, remember the rule, colon, no running with scissors. That's it. That's what the colon is there for. That's what colons are appropriate for. So please be careful how you're using a semicolon. There's no need for you to for you to replace, even though we're listing something in the example above. There's no need for you to replace the semicolon, the colon there with a semicolon. Semicolons are not commas, obviously, right? So don't use them the way that you would a comma. In this case, 6 of the applicants had background in writing, comma, but only 1 was a journalism major. So again, semicolons are not the same thing as periods, and not the same thing as commas, and not the same thing as colons. So don't use them interchangeably. They each have their own specific rule. Just something to remind you of, so you have a little better clear understanding. Apostrophes, we're talking about the rule of possessives. Some people tend to get these confused. Remember, very simple rule. In general, if the word does not end in S, you form the plural of that word by adding the apostrophe S. So Sarah's house, the computer's cord, right? You're adding the possessive to that word, right? And that's how we sort of get into that pluralization rule. If it is a singular, right, that ends with an S, sometimes we have words that end in S's that are still singular. Add the apostrophe S unless the result is hard to pronounce. For example, witnesses' testimony, the Joneses' claim, right? I think these are examples of what we tend to get a little confused. Like, we already have the S at the end of the word, so does it still need to have an apostrophe? Yes, sometimes it still does, as long as you can still pronounce it. If we have a plural that ends in apostrophe S, add just the S apostrophe. So the participants entry forms the Joneses claims the lenses cost. These are plural words that already have S, so you just add the apostrophe after the S. You don't need to add the apostrophe S to it. The participants entry, you're talking about multiple participants and their entry forms were completed, what have you, so you just add the apostrophe to it if the word is already plural and ends in an S. All right. Very, very simple rule. Again, possessives, they tend to be a little confusing, but they're very, very simplistic. Just remember the rule of whether it's singular that ends with an S, or whether it's plural that ends with an S, and you should figure out where to put the apostrophe, or just the apostrophe S, or just the apostrophe. Joint possession requires only one apostrophe S. What I mean by that is Jane and Charlie's apartment, they have one shared apartment, so be on the lookout for the noun there and what's happening with the nouns. So Jane and Charlie's apartment, they cohabitate, they have one apartment, so they have one shared apartment. We only need to have one apostrophe S versus Jane's and Charlie's apartments. Here we're talking about two different apartments. The subjects here, Jane and Charlie, do not live in one apartment, so each one of the subjects has to have an apostrophe to it, right, to add the possessive there. So remember, be on the lookout. This could be a bit of a distinction here when we're talking about the singular and the plural again. So Jane and Charlie's apartment versus Jane's and Charlie's apartments, right? We're talking about two different apartments versus one shared apartment. Apostrophes and contractions. Very simple rule for the apostrophes and contractions. Use apostrophes to form contractions, but while you are on the topic of that, use them thoroughly, thoughtfully in formal legal writing. To be very careful, any type of professional writing tends to avoid contractions. Mike's running late, spell it out. Mike is running late. Can't versus cannot. Wouldn't versus would not. I would always suggest you avoid the contraction there. It's just a rule of thumb for all writing, not just legal writing. Use them very, very sparsely if you have to at all. I would just recommend you tend to avoid contractions. Spell out the word cannot, would not, did not. It just makes your writing sound more professional. A couple more things about apostrophes. Distinguish between it's and it is. The car needs servicing because it is time to change the oil and its exterior is dirty. All right, it is. Keep that rule in mind versus it's. They're not the same thing. It is a contraction. It's so just be very careful with that. Distinguish between there and they are. They are going to be late getting there. Again, these tend to be a little confusing sometimes, but I think they're easy to follow if you just learn the rule. Whether you're using the contraction the right way. Hyphens and dashes, so there is a difference. I know I might be picking hairs here, but there is a difference between a hyphen and a dash. A hyphen, simply put, is just a much shorter punctuation marked, used between compound words to separate numbers, for example. A dash is a much longer one, mainly used to indicate an interruption or a change in thought, right? A couple little tools I have for you. So hyphens do not take spaces, while dashes generally do. To pick 350 of them. So for example, if I have 300 through 450, then we're using the hyphen. The weather and its abrupt change is remarkable. See the difference there? We're just using them to either mark off a compound words in a sentence, or to actually express a complete change or a new thought being added there. The dash, typically they take a little more into detail here. When they signal an abrupt change or an interruption there, just to give another example, the anxious applicant thumbing through his resume sat patiently in the waiting room. Again, we use a dash. You would use a dash there. Hyphenate right, 2 or more words. When they come before a noun, they modify and act as a single idea. It is called a compound adjective. We usually separate a compound adjectives with a hyphenation. An off-campus apartment, state-of-the-art design. The noun high school versus high school student would get that compound adjective treatment, and so we'd use a hyphenation versus a dash. Do not hyphenate prefixes. Pre-trial, non-compete, anti-terrorism, post-judgment, co-worker. These are all prefixes. You would never use the pre-trial. You never use the pre-hyphen trial there. There are exceptions to that. There are exceptions to that rule. Something like when the noun or adjective after the prefix is a proper name, anti-American, use a hyphenation. Post-Obama, use a pre-Viking, something like that. With a lack of hyphen would create confusion, either because of the strange vowel combinations, anti-inflammatory, extra administrative, co-opt, whatever, or because it would look like a different word without the hyphen. Resign versus resign, co-op versus coop, right? So they tend to be, there are always exceptions and more exceptions to the rules, but these are just some common things to remember about hyphenations. Most of these will come very natural to you, and again, you'll always have the word processor to do some corrections for you. Just a couple rules to look out for. Quotations. The rule of thumb is always when we're trying to use quotations, we have specific functions for quotations. Put commas and periods inside of our quotations. Always remember that. Other punctuation marks go outside unless they are part of the quoted material. For example, emerging democracies should legislate by enacting broad laws called standards, as well as narrow ones simply called rules. Here we have an example. We see the comma goes within the quotation, the period goes within the quotation, as opposed to when you're asking a question, or when you're asking a question in that one, should emerging democracies legislate by enacting broad laws called standards, or by narrow ones simply called rules? We see there the question mark would go outside the quotation. Let's take a little pop quiz here about the use of exclamation points in writing legal business. We're almost done with the basic grammar rules, but let's take a look at this. So, do you ever use an exclamation point when writing a legal or some sort of business in a business context? Does anyone know? Well, the rule is sometimes, maybe, but not always, right? Exclamation points signal tone, right? Specifically the type of tone that maybe might sound a little too aggressive, right? Exclamation points about exclamating something, right? So the attitude or the perceived attitude that you're putting into the tone of your paper will sometimes affect its meaning. So always think about what context you're writing this in. If you're writing an email to another lawyer colleague, then maybe certain rules can be relaxed versus whether you're talking to a judge you're not familiar with, something like that. What manner of communicating, writing an actual professional letter versus an email, things like that might be important. But just as a rule of thumb, remember that the exclamations add emphasis or show emotion. So let's take a look at the example I have here. Very simple email I might send out to a colleague, right? I think this is a perfectly fine email. If you wanted to begin, if I'm familiar with this person, I want to begin with like, "Hi, David. I hope you're well and enjoyed your vacation in Cancun. I'm expressing excitement that I hope they enjoyed themselves in this wonderful tropical paradise they went to." Right? And that'd be fine if I wanted to use that exclamation point in a familiar context with them because I know this person, versus using exclamation point that really wouldn't be necessary throughout the email, maybe to someone I didn't know so well. Active and passive voice. Oh, this is actually very interesting. So one thing that people tend to forget when they're writing is the difference between active and passive voice. Active voice describes a sentence where the subject performs the action stated by the verb. Passive voice, something very similar. In this case, the subject is acted upon the verb. Usually that's how we tell the difference between active and passive voice. Harry ate 6 shrimp at dinner. That's active voice, versus at dinner, 6 shrimp were eaten by Harry. As you can see here in the second example, the subject here is being acted upon by the verb instead of the other way around. The subject performing the action on the verb. Harry ate 6 shrimp. He's performing that action. He's performing that action on the verb. Beautiful giraffes roam the savannah versus the savannah is roamed by beautiful giraffes. We try to use the active voice as much as possible in all legal writing. So try to avoid these passive phrases. It shows less authority in your writing. Final thing, so let's have a little review. Let's see here if you can just take a moment. Again, you're welcome to pause this part and just see if you can catch any errors. What errors do you see here? Are there any errors to begin with? And then maybe correct it for yourself. So like maybe take a minute or two, read the phrase, pause this presentation now, and then let's see if we can find the corrected answer after everything we've gone over. So look at the comma placement, look at the colon placement, the active voice versus passive voice. Let's see what's wrong with this sentence here. So here's the corrected version. Very simple, and I didn't want to go too far into this. So just 3 simple things that are missing here that we should take a look at. The comma there after warrants doesn't really belong, and we're missing 2 commas in there as well in the corrected version of this document. So again, very simple grammar rules that I wanted to go over. I'll end off this section by giving you guys just a couple suggestions and revising tips for you to always keep in mind as you're going through your revisions. Reading something out loud, reading the entire document to yourself out loud is much better than just sitting quietly reading it to yourself. By reading it loud, you get a sense of the tone, the natural pauses, and the flow for your writing, and that might help you catch some of these mistakes. Maybe you forgot to include a period or the proper punctuation here or there. So reading something out loud really does help. And what's even better is having a colleague or someone else read something to you out loud. Have two voices in there, making sure that everything is going correctly. Omit any needless words. Again, get to the point, be concrete. Rely primarily on action verbs and nouns. Again, getting closer to the active voice rather than the passive voice. Check if you have any variety in your sentences and the length, right? And what I mean here is variety in terms of not making that structure boring, right? Beginning every sentence, right? Instead of going back to that very basic structure of like in A versus B versus C, what have you. You have variety in your sentences, so you're not using the same transitional phrases every time. If you're transitioning from one paragraph to the next, you're not always using also here and also there. You're using therefore, moreover, the other transitional phrases. There are a few for you to choose from. Your paragraph lengths, is one paragraph 5 sentences long versus another one that's 10 sentences long. How to try to have more uniformity between all of them. Make topic sentence outlines for yourself. Again, during the pre-writing phase, this is going to be so much easier for you guys if you plan out your writing and you plan out what those topic sentences are going to look like, what it's going to be the topic of each and every paragraph, so you know how to transition from them very smoothly. And again, like I said, ask a colleague to review your draft. Having 2 people there, or 3 people, 4 people reviewing your draft is going to help you guys so much. And it'll really help you catch the nitty-gritty details, right? Maybe those every once in a while you'll have a weird comma placement or something that you might miss yourself, but you'll have maybe someone else will catch it for you. All right. So just a couple little tips and tricks for you guys to follow, so you're a little better inclined going forward. All right, so that section brings us finally to the last portion, where we'll actually take a look in depth at some actual legal documents. We'll take a look at emails, briefs, affidavits, things like that, and see how we can apply some of the rules and guidelines that we set up so far to actually produce good legal documents, good A+ legal documents. And this will be the final portion of the webinar. I know we've gone through a lot, but we're almost there. We're almost to the finish line. So relatively short section. So let's focus on a couple details. And I want to begin with case briefs. Just because this section involves more than anything that idea we've been talking about of summary, right? In general, a good case brief will succinctly and clearly summarize the relevant facts and legal issues presented, the reasoning of a court being used to reach the case. And so I've detailed for you some of the key features that all legal briefs should have, right? The name of the case, the court date, facts of the case, etc., etc. And so you might be thinking to yourself, well, you've been telling me all this time, well, we can't just summarize so much. And even though that's true, and the legal cases might, the case briefs might be one of the few exceptions to that rule. One section that people tend to forget is that although we are mainly sort of restating some old information, analysis is still relevant in legal briefs. So that's one thing we tend to forget. I would suggest adding one final section, right? Even though this is mostly dealing with summary, we add a section of your own observations and criticism, right? So there has to be a purpose behind you summarizing all these important facts, and I feel like having a good final section there, a good final analytical section there, where you're giving your own observations, right? Where you're giving your own when you're dissecting everything you just examined and providing a criticism for it. I think it'll help your legal briefs out a lot more, and it will strengthen them in significant ways. So this is one moment where we can actually begin to shift from that summary and actually use that summary to form effective analytical discussion, which ultimately will benefit your paper, I think. A couple goals, and some of these sections will appear very obvious. These are things that you already should know, you should be familiar with, just as part of your legal career, your legal training. But I want to apply some of these goals to actually effective, good legal writing. So I've summarized a couple good key points for you guys to remember in terms of your legal briefs. Just read multiple times for comprehension. Be able to clearly track that chain of argument that led one judge to rule the way that he or she did as you're progressing through the briefs. And try to keep when you're noting something, try to keep any helpful phrases to just like specific yes or no questions. Things that might help you out. Good critical analysis, right? A good brief will examine the process the court took to reach its decision. So this is where that good analytical writing comes from. We can strike a better balance between just a plain summary that's mandatory and then you actually providing some of that good critical analysis that requires you to really delve deep to the actual process of it, right? So the process is not just about restating something, it's also about really examining and picking that process apart to really identify and examine it. That's really important. So here's where we can begin to form that analytical writing. I would use, and here I have like just a general example of how would go about structuring the brief. Lead with what matters, right? Begin with some of the most important part. And the sections in green that you see in front of you are just my examples, some examples that I'm using to help sort of illustrate what I mean by this. Use story and theme, right? Try to track, again, this idea of flow. Try to track how you're going to develop your ideas, right? Sort of maybe lay out a general theme that you want to lay out for yourself. And by theme, I don't mean, there's not fiction piece, or you're not creating like the deep themes of the Great Gatsby or whatever. You're just creating like a general theme or a general guideline or a general flow that you want your the information to flow from. State the law and then analyze it, right? Here's a perfect example where you're stating the law, where you're just reciting something, and then you begin to analyze it, right? So in this case, I have here Miranda applies, where a person is, quote, in custody, what have you, and then the next part would begin the analysis. A person who has been formally arrested is, quote, in custody. Interrogation includes both express questioning and police words and actions, so on and so forth. Here, where you're examining and breaking down that that portion there. Citations are mandatory, so cite as much as possible. Quotes are even better, so use quotations as much as possible. And again, here's where we start taking into consideration how much is too much quoting, right? How long should the quotes be? When should they be indented a bit? Footnotes, how am I using my footnotes accurately? So keeping all these things in mind, right? Applying these general rules that we've already followed, right, into your actual legal writing. And then conclude a concise statement of what you want. Again, that wrap-up sentence that we talked about in our organization, that wrap-up sentence that sort of goes into that concluding portion that might be really beneficial to you, that might help you over time. And if I could, so one thing that I really want to get across in terms of for brief specifically is how we can use sort of that outlining model that I showed you a couple of slides back in order to really produce the best results for you. And in here in this slide I have a nice little model for what outlining a brief would look like. And I think if you do it this way, if you take sort of the most important facts and you get all the sections done first, right? Before you begin worrying about sort of the general language and the structure of it, as long as you get all these sections done first, right? Then you can worry about perfecting it, right? So you get the sort of the basic facts of the situation onto your general outline, what you want to discuss in each section, right? And break it down very similar in the sections that I have there in green, right? Where you're sort of like step by step, just baby steps, illuminating any issues for yourself, like going through the whole thing and realizing, well, maybe this section works, maybe this doesn't, maybe this is relevant, maybe this isn't, right? All good legal writing is going to take you time, right? It's going to take you time to really and deliberately make choices about what is going to go in each paragraph. You just don't want to go into it half blind, right? Cater specifically to what the judge that you're writing to maybe wants to look at, and it's fine. And be confident with your language. Again, you're trying to persuade, right? So instead of saying like must, say should, right? Even your language, right? Even though you may not be speaking with someone directly, you may not be engaging with someone directly, your language will reflect how persuasive you're going to be, how declarative you are in certain statements, and maybe if you're feeling some of that ambivalence that we talked about earlier. So that's just a nice little model for you guys to follow, really breaking down what the substance of that brief is going to look like. And I think ultimately by modeling and outlining like this, that it'll help you guys tremendously. I'm also going to give you some common faults that I see in briefs that can be improved in the revision process. One of the things, like, never accept court opinions as gospel, right? Always be questioning, and again, this helps with the analysis as well. If you're questioning the facts, the issues, the reasonings, if you're checking for fallacies and logical flaws, right? Then that means that you are doing that dissection, right? You're beginning to sort of pick apart and interpret and reason your way through an argument or an opinion, and be able to criticize it, right? And by criticizing, you are able to form those analytical sentences, right? Form the basic analysis and argument in your writing. So going back and not really accepting something like that as gospel is really important. Dicta is not law. Look out for words or phrases like such as if, for example, suppose, etc. Right? These indicates that the statement is an example, analogy, or something else. And looking out for these little moments, right, are really crucial. Because again, going back to the analysis, that'll help you really dictate and piece apart how you want to go about tackling this argument. And don't skip on the reasoning. Always, follow through. It's okay. Your analysis of the court's reasoning should not be shallow, right? It could damage your credibility if it is. So always go into good detail. And that's, I think, the most important takeaway here is expressing the information accurately, but also expressing the information as persuasively as possible, and that your reasoning is logical and analytical. Don't include too many details, right? Trivial details specifically, like personal information about the parties, for example, don't necessarily have to be included here. Focus only on the bearing of the court's reasoning in their decision, right? That's really important. Again, not engaging with these long, convoluted sentences. Going back to our basic rules, right? Be concise, keep it simple. And then I have just a few weak briefing methods that don't really make for good analysis or good reasoning that you might want to focus on. Going back and just looking at the head notes, for example, like that's not good. It may offer a simple summary, but it may not give any nuance or analysis, right? So really delve into the key issues, right? Always be looking for, how can I tear this apart even more? How can I really get all the strands together and really understand what the problem is here? How can I interpret this? And lay that bare in your outline, and then fill in the rest, right? Once you have that, your job should be pretty simple, right? If you've done the job of really going through the information and learning as much as you can about it and figuring out how the nitty-gritty of it works, then establish a structure for yourself, go point by point by point. The rest is just filling in the blank, right? You already have the information, it's just filling in the blank. And you're confident that you have the right information, that you know what you're talking about, and so that should make your writing so much smoother and so much easier. Emails. I want to talk about emails next. And emails are going to be one of the most common things that you're going to send out, right? You're sending out emails probably every day now. But there are a few rules and regulations you should follow in order to construct a good email. And the first rule, again, my favorite, make them short. Emails should be short, right? Say only what the recipient needs to know, okay? Just be very clear and very direct. One of the things that I want you to get out of this specific email section is how to avoid that really long time-wasting process of that email chain you get stuck into, right? We send an email to a client or to a colleague, right? And you think to get an answer, right, in one reply, and instead it takes 5, 6 different emails going back and forth all hours of the day, right? If you're really busy, I want you to avoid that, right? It doesn't help you out. It wastes a bunch of time, and it's really unnecessary. And why people do this is because they don't know how to craft good, effective emails using the rules that we've established. So be short and to the point. Be direct, right? State the purpose of the email within the first few sentences. Don't draw it out, but with that direct way of stating your purpose, you don't want to come off as rude. You want to be polite in your emails, right? Be direct but professional. I know very curt language could seem like rudeness, but really if you only need one answer to one question, you really don't want to fill your email with a bunch of schmaltzy language that's going to maybe confuse the reader. It's going to draw the reader out to maybe expand on their answer more than they needed to. So you really want to keep it direct but polite. Address only those who actually need to be addressed in the email. Be careful who you're CCing or BCCing, and especially if you're replying all to in your email. This is more just a guide for you, because if you're including maybe 5 different people that don't need to be in the email, then you're getting 5 different answers, right? So only really include, and try to look out for this, who needs to be really included in the email. If you can get your answer from one person, only get them directly from that one person. You really don't need 5, 10 different people emailing you back. You may get 5, 10 different answers, right? So just be careful with that. And finally, specific and short subject lines. So in the subject line, make sure you're putting the exact purpose, right? Consider it the introductory paragraph of your email, right? State what your purpose is, state what your thesis is, right? That way, they are more likely to respond back to you quickly, and they won't be confused as to why you're sending them the email if they know the specific subject of it first. Some goals for emails. Professionalism is key, right? Be professional, but be direct. Even quick emails, right? Even if you're just sending a short little quick email, should always follow the conventional rules of punctuation, grammar, and style, right? Even an email to like a colleague, for example, should be somewhat professional. If this is someone you get along with and you know well, okay, we can relax the rules just a bit, but all emails, and this is just a personal rule that I like to follow, all emails, no matter how short or long they are, always go through a revision process, right? I just never send a first draft of anything. I literally never send a first draft of anything, neither should you. why do we do this? Well, some words like refilled and refiled can be easily confused, right? The difference is one L. You know, your word processor isn't going to catch that mistake because it's going to read the word correctly, right? But if someone else is reading it, and if you're lucky enough to get a person who might be a little nitpicky, where they see a refiled instead of they see a refilled instead of refiled, then, well, you look unprofessional, you look like you're rushing. So really, maintain that first impression, maintain the good first impression, and make sure everything is professionally edited, organized by through the grammar rules, even through a short email that you're just sending a friend. It makes much better impression. I remember I received an email once from someone who was offering me a job, and they had, in a very short email, 2-3 sentences long, they had about 15 different grammar mistakes, and they were so simple. It was mistakes that could have been resolved with just one simple read-through, and instead they sent out a very sloppy email, and it really made me not want to go interview for them, because if that was the type of team that I was going to work with, it just wasn't going to be my type of environment. So really, having a nice professional email along with the signature block. The signature block should always include your name, your title, your organization, your email, and your phone number. Things like that, they really do count. They may seem aesthetic, but aesthetics matter in this profession and in most professions as well. So make sure you're using the proper size and format. You're not capitalizing, sentences. We all know that, capitalizing means you're yelling at somebody. And even in your smartphones, right? We all have smartphones now. We tend to send emails electronically. Edit your footers on your smart notes as well. That's something that doesn't get edited automatically once you do it through your regular desktop computer. So always be on the lookout for those. And here, I want to take a quick little breather, a nice little breather for me. It gives me room to drink a little bit of water, and also gives you room to look at the access code. So that's the access code you're going to have for the CLE credits. So if you stuck with me this whole way through, just please stick with me for another 10 minutes. We're almost done. I have maybe 10 more slides to get through, so I'll get through them really quickly. But that is your code. Just type that into our PracticePanther website, and you'll receive your certificate of completion, and you will get your 2 CLE credits. So that's your code. Feel free to jot that down and just go to our PracticePanther website, and all that information will be at the end. All right, so back to your emails. So like the grammar rules, there are always exceptions to some rules, right? In this rule of brevity, I've been talking about how most of your documents should be as brief as possible. Now, sometimes in a professional environment, our emails will be used to send out maybe research reports in lieu of like an actual memo. And this will require you to be, precise and clear and answer the question as thoroughly as you can, as it can be answered. And so it doesn't always leave room for brevity. That's fine, right? But one thing you should remember is that you don't report your findings without restating the question, and your summary should be very thorough and include all the information that they need. So let's take a look at an example of what I think a bad email will look like on both ends, and what leads to all this clutter in your inbox, and what leads to really unprofessional emails, and what leads to these long chains of emails going back and forth. Really, there should only, if you're asking someone a question, there should only be 2 email sends. One email is sending to that person with a question, and the second email you get back is their response, and that's it. It should end from there, right? Unless you want to send them a quick thank you or what have you. But let's take a look at the example here. And so the example in purple, it's a question being sent to somebody, and they're replying, meaning of sale under the act. Please look into whether a sale actually took place on the evening of May 19th. So they're referring to a case here, right? You're sending it off to another colleague who may be working on the case with you, and you get the response, the section in pink, right? Meaning of sale under the act. Almost certainly, several witnesses have said midnight furnished an inebriated person with alcohol in his establishment on May 19th, although midnight, and they go on and so forth. So some of the things that I want you to really look at this question, at this email here, is what's happening here? Is there any background, right? What is the act that this person is talking about, right? I received an email that just says meaning of sale under the act. What is the act, right? Am I able to reply to that question accurately, right? If I'm given such scant information, right? Can anyone, and a way to test yourself is can a layperson just pick up this email chain without any context for it and know what's happening? I can't do that with this example, right? If I was just to open up this example, right, and take a look at these 2 paragraphs of writing, I would be totally lost. I have no idea why sale is even in quotations. Are we talking about a real sale in the way we know it in terms of commerce? You know, what is this act that's being cited here? This con, gen, stat, and 30 through 1 west, and like that may make sense to the person sending back the email, but it doesn't make sense to me really, and it may not even make sense to the person that's receiving this email. This is an example of very, very, very poorly drafted email, and we need to severely improve. So let's just compare this poor draft to what I think is a much better draft, right? Where we actually start taking into consideration not just detail and clarity, but proper grammar as well. So we're applying meaning of sale under the Dram Shop Act. There it is. There's the actual act. A nice next section, the question. You know, the Connecticut Dram Shop Act requires a sale from a bartender to a patron, so on and so forth. And my question at the end: did the rounds of beer constitute a sale to all 8 guests? Right. That is the question. That's what I expect an answer to. So I'm receiving an email back, the section in green, detailed, perfectly appropriate, answers my question, right? I know exactly what the focus of this question should be about, specifically if sale is encompassed under that Dram Shop Act, right? And I can get a clear, definitive answer, right? You know, short, little, 1-paragraph sentence. No more need for any other emails, right? Focus, to the point, brief, with all the information that I needed summarized specifically in one section, and then the rest enumerated for me. Easy, simple way of drafting your email. Much more effective way of crafting your emails. Let's move on to affidavits. All right, affidavits. They're important. Another document you're going to be writing consistently throughout your practice. So I'm sure most of you already know this information. So I want to focus on, again, doing what we did with the emails and doing a more comparison and contrast, right? Seeing what just a poor example of an affidavit looks like versus what a really good example of affidavit looks like, right? So always keep in mind, a goal for good affidavit writing is that, you know, before you write, decide which facts are relevant, right? Don't an affidavit to make an argument or sway a reader, right? Just go for the facts and begin from there. And be careful with the wording, right? Include only specific and factual statements, right? If the wording only acknowledges a fact as true rather than recites and swears the truth of that fact, right, then you're not necessarily writing an affidavit. So again, wording matters. So be very careful when you're doing that revision that your wording is very strong and precise, right? Going back against those rules. A couple of rules for evidence, and again, this should be relatively clear to you. I mean, you're all lawyers, you have legal training. I thought it was worth pointing out some of these rules for evidence, just to make sure some of the things that when we're revising, we're looking back on the right things, and we're organizing, or even when we're pre-drafting, right? When we're organizing our ideas, we know exactly what order and structure to give it, and what we should be looking out for. But a couple of things that we want to avoid, or a couple of faults that we want to avoid, is again this idea for overly formal, jargon-filled language, right, or legalism, right? Yeah, we don't need statements like "who being duly sworn deposes and says yada 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 yada." Get to the point. Try to use plain English as much as possible. Again, don't try to sound smart. Never write in the third person. Always write in using first person pronouns. Very important. And don't ramble. Don't be long-winded. Have these long, drawn-out sentences that might be open to misinterpretation, or maybe go off the rails a little bit. Again, focusing on that number one important rule for good legal writing. You know, keep it simple. Keep it concise, keep it clear, right? Affidavits lend themselves to a lot of overly drawn out language. Don't do that. Try to avoid that as much as possible, so keep that in mind. That's one of the most important things, along with, you know, rules or evidence, stuff like that from the previous slide, but just word of advice for good, better writing. Never tweak or improve facts. Very important. You can only report facts in affidavits. So again, this goes back into the tone, right? When we're talking about tone, something like charging or describing someone or using an emotion-filled word like malicious or heartless, right, to describe someone might be considered, slanderous against them, right? It depicts a different tone than the one you want to go after. So when you're looking out for tone, look out for specific word use, right? So be very careful about that. You always want to, this is why tone is so important sometimes, even though it might seem like an aesthetic quality. It really does reflect, especially for something like an affidavit, it really does reflect how accusatory you might be towards somebody. And you never want to do that. Just report the facts, report what's there, and you can get away from a lot of trouble that way. Okay, so even something as mundane as tone really does count for some pieces of legal writing, like an affidavit, for example. So here we have a sample of an affidavit that I have here for you. If you want to take a moment to just pause the webinar, read this over. It's like a little bit of a quiz here, but I want you to notice what is happening with this affidavit, what is sort of going right, what is going sort of wrong with this. So maybe take a minute, pause the webinar now, take a look at it, read it over, and really decide for yourself, what do you see? Because I'm noticing a couple of very specific things about this affidavit here. First, I think it's doing a nice job of laying out the facts, like all the webinar does. It's numbered, right? So we have a numbering system that sort of lays down every paragraph. It's clearly organized. I like it. It's doing a very good job of at least being orderly and organized. So good job on this person for that. But what are the faults that I'm noticing here? One of the faults I'm noticing here is that it's leaving, I think, one of the most critical points, right? Point number 6 there. It's leaving one of the most critical points to somewhere in the middle of this, right? And that's not really where that is supposed to belong, right? Your purpose, your thesis, the most important part, should go way early. Tell me the purpose of this from the very beginning. And even the writing style itself, right? I'm noticing is that a lot of these statements from this affidavit, it's almost as if this person is just reciting someone else's information instead of them providing that information themselves, right? Just a general wording like unicorn sells about 500,000 books and has sales revenue of 1 million. So this person is not really speaking from the perspective, or at least the writing is coming off as them sort of reciting facts and figures instead of them being a person who's a testament to those figures, right? They know professionally that these are facts that are happening, right? So these are some key things that I would like to see fixed in this affidavit, right? And they aren't necessarily major errors, but they do sort of weigh poorly against this one, right? There are little things that we can fix here to just make it stand out even more than it does already. So again, sometimes it's not as big as just having a jumble or a mess of words and phrases all in one paragraph. Sometimes it's little things like that, like forgetting to include your most important statement earlier in the affidavit, and the general structure, what verb tends to using active or passive voice, that really tends to spoil the most of the affidavit and most of your writing. Pleadings. Pleadings are very simple. Again, to apply more of these rules to it, I just have a general layout, some of the things that a pleading should do. We should all know this. It's very simple for us. But some goals for your plead, right? When you're drafting, especially any pleadings, make sure you want the court to rule in your favor. So again, going back to that persuasive writing, back to your tone and your analysis, that's where the person is going to come from. And also make sure that you give the court an impression that you're authority, right, upon which to base that decision. So citing everything correctly, having your footnotes ready, and be able to really strategically analyze your case and decide how would you like to present it to the jury. Another very important part of that pleading, right? So almost adapting that pre-writing phase. This is also if you're gonna use in your pre-writing that you're then gonna draw and expand upon for the rest of that pleading. Definitely, you're gonna have to have some of those rules come into play. A few things that you want to avoid, like always, follow specific rules for each jurisdiction, right? Everyone has their own form, but make sure that your pleading improves some that your pleading includes some really essential information, a succinct statement on the grounds of the court's jurisdiction, a succinct statement of the claim showing what the party is entitled to relief for, and a request for relief, right? These are just all important things that you should remember, and these are things that will be included right from the get-go, right? ASAP, you would just get that information out there to you in whatever way you wanted, right? If I could just like look at this example, very short, very sweet, very specific, right? This pleading, and if again you want to pause the webinar now and just take a look at my example there. This draft is done very much in plain English. It keeps it concise, right? It's tailored directly to the facts of the case, right? There's a specific claim right early on, using the current law and local rules, and I find this amazing. This is an example of a really great specific brief that's perfectly worded. I could read this. I'm fine as a non-legal expert. I could read this and understand it. So I find this a very nice, concise outline and perfect basis for a good dispute, right? So this I think this is a really great example of a brief and sort of what a brief should, a pleading should look like. Motions, this is the last thing we're going to cover today, so motions will be another one of those important documents that I really wanted to focus on and talk about here and just give you some more advice on, and because of their very specific purpose, right? You know, they help educate a judge about the merits of your case and things like that, so this is where you want to make sure to leave a good impression, right? You want to make sure they have a clear understanding of the legal theory involved here, so you want to present that information in the best possible way. So always think about drafting and pre-writing as the most important part of your motions, right? Think about what advantages you seek, right? Always have everything very nicely organized for you, so you can get to your information right away. When you're talking about writing your brief, when you talk about drafting your brief, as you go about it, make sure that you're sort of doing these wonderful techniques, that you're taking some of these rules to make a much better writing sample than the ones we have here. So take a look at the one in red, right? When you say defendant X, in accordance with Federal Rule of Civil Procedure 12, hereby moves to dismiss Court 4 as the compliant filled plaintiff Y in support, that may make a lot of sense to some people. Not necessarily for me, right? So I would rephrase that as defendant's motion for summary judgment on Court 4 should be granted because discovery has shown that there is absolutely no evidence that defendant did X, Y, and Z. You see how much easier that is? You see how we're moving across from this very convoluted, very complex legal language that took way too long for me to read, as opposed to me getting to the point, right? Me telling you exactly what the purpose of this writing is for these reasons, right? Always err on that side, right? Always err on that side of going for simplicity, concreteness, right? And conciseness in your writing instead of going for this very lofty language. You don't need. It's not 1847. We're not. You're not addressing the magister of the court, right? Always settle for that type of language, right? And even this type of language, even though it may seem more simplistic, it's still maintaining a very professional adult tone, right? There's no questions about it. There's no ifs, ands about it, right? A couple final little goals for a good motion, right? I would recommend you get to the point, like I was just saying. Summarize the issues very briefly. Say how you think it should be resolved, and then briefly explain why, right? Here you're telling me necessary information. The less important details should be left for the main body. Just maybe even for a footnote, and try to win the motion within the first page and a half. I would recommend. This is where you want to start laying out your strongest argument first and then saving everything else for a little later, right? Cite often and cite as much as possible, right? And don't just try to use fill in the blank motions. I know you can try to fill in the blank yourself from other previous motions. Don't do that. It's not very good. Just keep that rule in mind in order to avoid any difficulties later on. And last but not least, always make sure to double check your facts and citations. Any citations that may misrepresent a fact, right? Reflects poorly on you as you're competent as a writer, and it wastes the court's time. And again, this is all part of the revision process. Your language should also be very persuasive, right, and precise. So just be careful with your language. Use accurate language. And again, these are all things you can go back and revise. You'll plan out them in the pre-drafting phase, organize them, and then have everything written down, and then revise. And these are just very simple ways of applying the rules and procedures that I've taught you into your legal writing so far. Okay. And I have an example here. Here's another example of a good, well-written legal motion, right? And in this sample here, one of the things that I actually improved on this is that I took out any use of this information, right? And I just, from the beginning, right, I just encapsulate my main reasons, right, that the court should grant me this summary judgment. And so I have the basic facts there. I have the information I need. Everything is summarized and analyzed very effectively, and I don't have to waste my time anymore, right? I'm not wasting the court's time. I'm not wasting anyone else's time, right? Good, wonderful way of drafting a motion. And again, you can pause the webinar, take a look at this, read this, and see what else you find about it. But I think this is a nice example, a good example of a good drafted motion. All right. And that brings us to the end of our webinar, the end of our 2 hours. Any questions, any comments or concerns can be directly addressed to us. So we love hearing back feedback from our clients and our Panther family here. I hope you've enjoyed this webinar. It's been a pleasure to have you guys here. I hope you enjoy your 2 CLE credits. If you have any issues at all, please, my contact information was included in this webinar. You can always come talk to us, send me an email. Be happy to address any other questions and anything else you might have concerns with. I hope I've done a good job of getting some of these basic English and humanities grammar tools that we like to use for general writing over into the legal profession. I hope they do some good. I think they will. I think you'll definitely notice an improvement in terms of like your professionalism and how people view your writing if you just follow some of these principles and apply them to not just the legal writing that I showed you today, but any legal writing that you do from here on out. All right, everybody, enjoy your day. I will see you around. Bye.